No apologies have been received. This meeting has been convened for the purpose of consideration by this Committee of the Local Government Bill 2018. Before we begin consideration of the bill, I propose to deal with some minor housekeeping matters. So item 1, in order to ensure the smooth running of the meeting, any member acting in substitution for a member of the committee should formally notify the clerk now if they have not already done so. Item 2 is that I propose that after 2 hours of consideration of the bill that we would take a short break for approximately 10 minutes. And item 3 is that at 10 p.m, if consideration of the bill is not concluded, I propose that we consider whether to continue with consideration of the bill or not. Is that agreed? So we'll just see where we are at 10 o'clock. Is that okay? I would like to welcome to the meeting Mr John Paul Phelan, TD Minister of State at the Department of Housing, Planning and Local Government, with special responsibility for local government electoral reform, and I would like to very much welcome his officials also to the meeting today. Before we begin, I would ask members to please ensure their mobile phones are switched off or in airplane mode for the duration of the meeting, as they interfere with the broadcasting equipment even when on silent mode. We will now proceed to the consideration of the bill. Section 1, there are no amendments, so that the question is that Section 1 stand part of the bill. Is that agreed?
Agreed.
Thank you. We now move to Section 2, Amendment 1 in the name of the Minister, and that is 1 to 3 amendments inclusive, 25 to 28 inclusive are related and will be discussed together. Minister.
Thank you, Chair. Thank you, members. I move amendments numbers 1, 2 and 3. Amendment number 1 is a drafting amendment to Section 2. To insert an additional reference to the map as having been deposited in the Custom House on the 25th of July 2018 for the purpose of the Cork boundary alteration, and to reverse the order of the 2 paragraphs describing the deposited map in the published definition. Amendment 2 provides for the insertion of a new definition of staff transfer plan in the interpretation section. This relates to the new Section 13, dealing with staff transfers and plans. That is proposed for insertion in the bill by Amendment number 25. Amendment number 3 provides for the amendment of the reference to Section 17 in the definition of financial settlement to Section 23, which would be the appropriate section number based on the Government Amendments numbers 69 to 72 proposed to the bill. Do we go on to wish to speak on that? Yeah, 1, 2 and 3. 1
to 3. Okay. No, well, we agreed them all at the end.
Yeah, well, no. I can go on to...
go on to
25, there's 25, 26, 27, 28 as well. Amendment 25 proposes to insert a new Section 13 about the staff transfer plan into the bill before the existing Section 13 dealing with the transfer of staff. The new section deals separately with the staff transfer plan that the 2 local authorities will need to jointly prepare to facilitate the transfer of staff from the County Council to the City Council. Subsection 1 requires the 2 chief executives to jointly prepare a plan referred to as the staff transfer plan in the bill, which was added as a definition to Section 2 by Amendment number 3. It sets out the numbers and grades who prior to the transfer day were assigned to the performance of functions in the relevant area, and whether fully or partly, and the proposals to transfer staff to meet the staffing requirements for the relevant area. Then in relation to, there's different subsections in relation to Amendment number 25. Subsection 3 requires that any disagreements in relation to the preparation of the plan are to be referred to the Oversight Committee, who will make a recommendation to the Chief Executives. If the Chief Executives fail to act in accordance with such a recommendation, the Minister may give a direction on the matter under subsection 4, and in doing so, subsection 5 requires the Minister to have regard to the proportion that the population of the transferring area represents of the existing population of Cork County Council. Subsection 6 requires the Chief Executives to comply with any such direction given by the Minister. Subsection 7 provides that a staff transfer plan may relate to classes of staff by reference to their grade or the operation of services by the local authority. And subsection 8 requires the 2 local authorities to notify the Oversight Committee of the making of a staff transfer plan. Subsection 9 provides that the Chief Executives can make more than 1 staff transfer plan. And arising from the new Section 13 inserted into the bill by Amendments 25 and 26, it replaces subsections 1, 2 and 3 and the published Section 13 dealing with the transfer of staff with a single subsection which provides the Chief Executive of the County Council shall, after consulting with the City Council Chief Executive, designate for employment by the City Council the members of staff required to implement the staff transfer plan prepared under the previous section for the purpose of meeting the staffing requirements in relation to the relevant area. Once the staff transfer plan is in place, indicating the numbers and grades required to transfer, the designation of the individuals concerned will be by way of volunteers initially, and then a last-in, first-out basis to make up any shortfall. Amendment 27 reduces the notice period in the published section 13, subsection 4, from 5 months to 3 months, or any shorter period agreed with the staff member concerned, and this reduction is being proposed at the request of both local authorities. Amendment 28 amends the published section 13, subsection 5, because it is a County Council Chief Executive function to make staff transfer designation. And that's pretty much it.
Thank you, Minister. Jonathan?
Yeah, I suppose one or two, and I suppose some of the next few groupings, there's not that much in them, so I'm hoping there's a lot to get through here, so I don't intend to slow the process up too much, but this is a small bit of a change, not radically maybe from what was initially outlined, but in that it sort of inverts the process to some extent, in that both local authorities come up with the plan together, whereas in the bill, as I understood it, that there was an expectation that the City Council would outline what they required. Now I suppose it could work just as well, but what I'm conscious of as well is in Amendment 26, it seems to be that once this process is completed, provided that there's agreement between them, the obligation rests entirely on the County Council to designate that staff across. So, the potential for the Minister to intervene is before that, but could you have a situation where generally it looks as if there's agreement, and then at the last stage of the process things are slowed down, probably not permanently, but at whatever stage, this mechanism seems to rest more control with the County Council for transfer of staff across to the city than I think was previously the case, and then the City Council has. Just the other one there in relation to the 3 months, I appreciate both local authorities probably feel it's necessary in the context of look, things are tight and the time frame is tight, but I suppose just to ask that question, is it absolutely necessary? Because 3 months is tight enough for an employee to have to change either their responsibilities or potentially their place of work. That may be the case, particularly for outdoor staff.
Thanks, Mick. Have you a quick point to make?
Thanks, Chair. So I have a question or seeking clarification. It relates to amendment number 25. Amendment number 25 relates to the issue of planning for the transfer of staff. Planning for the transfer of staff is a key, sensitive, important part of these changes, and it's important that it be done right. So the clarification I'm looking for is I can support amendment number 25, provided that 13.7 and 13.8, that's 13.7 and 13.8, in the original document are not replaced or deleted. I think they're not replaced or deleted, but I'm seeking clarification and confirmation that that is the case. Sinead.
Okay, Minister.
The answer to the last question first, 13.7 and 13.8 are still retained. They're not being deleted. The numbering may be different because of what we're inserting, but they're not being taken out.
Or replaced.
Or replaced. Okay. In relation to the question by Deputy O'Leary, I suppose that what we're talking about is transfer of staff from the county to the city. So originally, most of the emphasis was placed on the county council, being the authority that were giving it up, and the city council were going to demand, or not demand, that's the wrong word, but examine what staffing requirements were needed to deal with the transfer of population. But it has become apparent at different stages in this process that if we can get agreement between the local authorities themselves, it's probably the best way to approach it. The purpose of the amendment, or the amendments, is to kind of place more emphasis on the fact that we are actually allowing them to come to their own decision themselves. Because what we have found in this process, now that the discussions are actually really getting into the nitty-gritty, there is a lot more agreement than might have been originally thought in some of the comments that were made at the start when the boundary maps were produced. So we want to place the greatest possible emphasis in the legislation on allowing the Cork authorities to come to their own agreement. But we still retain, as various of the inserts that I've discussed refer to, the fact that the Minister can ultimately become involved if there isn't agreement.
I'm just conscious there's a vote being called, so does that conclude your remarks, Mr. Donegan?
Yeah, it does.
So can I just ask members, so we can finish this before we come back, so can I ask members, the question is Section 2, Amendment 1, that amendment be made, Minister?
Agreed.
Thank you. So members, I propose that we suspend the meeting just to allow us to vote, and we will return in approximately 10 minutes. Is that agreed? Thank you. Sorry, members, we will now resume consideration of the bill in public session, and we'll move on to Section 2, Amendment 2, already discussed with Amendment 1. So the question is that amendment be made.
Agreed.
Thank you. Section 2, Amendment 3, already discussed with 1. The question is that amendment be made. Thank you. So the question is, Section 2 as amended stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 3, there's no amendments. The question is that Section 3 stand part of the bill. Is that agreed?
Agreed.
Section 4, no amendments. Question is that Section 4 stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 5, Amendment 4, in the name of the Minister. Amendment 4, 16, 17, 19, 21 to 23 inclusive. Amendment 64, 66, 73, 75, 76, 80, 84 to 86 inclusive. 1995 to 99 inclusive, and 101 are related and will be discussed together. Minister, you wish to move?
Yes, I move all these amendments, which are essentially drafting amendments rather than substantive changes to the provisions. Amendment 4 replaces subsection 2 of section 5, which is the directions of the Minister, with a new subsection that spreads the content over 2 paragraphs. Amendments 16, 17 and 19 are minor drafting amendments to remove superfluous commas in section 11. Amendments 21, 23, 22 and 23 to section 12 are technical drafting changes. Amendment 21 replaces subsection 2 with the revised text that replaces document with other instrument and clarifies that the provision applies to instruments made by the County Council and divides some of the content into 2 paragraphs. Amendments 22 and 23 move some of the content of the existing subsection 3 into a new subsection 4. Amendment 64 is a drafting change to make the word purpose in subsection 2 of section 19 plural, and amends number 66, and amendment number 66 is a drafting change to insert the word "the" before effective in subsection 3C. Amendment 73 replaces the words in respect of with "for" before the first occurrence of municipal districts in subsection 3 of section 21. Amendment 76 has the effect of making the published subsection 3 of section 23 applicable to interim polling district arrangements made by the County Council only. And Amendment 75 inserts an additional subsection 2 into the section that is essentially a repeat of the published subsection 3, except applicable to interim polling district arrangements made by Cork City Council only. Amendment number 80 amends subsection 2b of section 25 by changing after the transfer day to from the transfer day. Amendments number 84, 85 and 86 reword the provisions in section 26. The effect of the first two of these amendments is to remove the position of the words insofar only as it is not inconsistent with this Act in subsection 1. The third amendment rewords subsection 4 without changing the meaning or effect of the provision. Amendment 90 is a technical drafting change to update the collective citation of the Housing Acts in the published paragraph B of subsection 3 of section 28 to include the most recent collective citation contained in the Residential Tenancies Amendment Act 2015. Amendments 95-96 are two technical drafting amendments. Section 29, the first of which changes the place within subsection 5 of section 10 of the Local Government Act 2001, where the new paragraph referencing part 2 of the bill will be inserted, and the second of which changes the order of the words in the first paragraph of the first line of paragraph C of section 29. Amendment 97 changes the reference to Local Government Act 91 at the start of section 30. At the start of that provision, to use instead the abbreviation defined in section 2 of the bill. Amendment 98 adds 2 commas to the provision being substituted for subsection 2 of section 31 of the 91 Act, and Amendment 99 adds the word "and" to the provision being substituted for paragraph B of section 33 subsection 4 of the 91 Act. Finally, amendment number 101 to published section 31 replaces the words "material change" with "material change of circumstances," which is the full definition used in the Valuation Act section 3 provision in question.
Any comments from the Minister? No? Okay. So the question is that Section 5, Amendment 4, in the name of the Minister, that amendment be made.
Agreed.
Thank you. The question is Section 5, that Section 5 as amended stamp part of the bill. Is that agreed?
Agreed.
Thank you. Section 6 has no amendments. The question is that Section 6 stamp part of the bill. Is that agreed?
Agreed.
Section 7, no amendments. The question is that Section 7 stamp part of the bill. Is that agreed?
Agreed.
Section 8, no amendments. The question is that Section 8 stamp part of the bill. Is that agreed?
Agreed.
Thank you. Section 9, Amendment 5 in the name of the Minister. 5 to 15 inclusive, 18, 20 and 24 are related and will be discussed together. You wish to move, Minister?
Yes, I wish to move, starting with amendment number 5, Chair, which substitutes subsection 1 of section 9 with the provision that is to the same effect, but which is subject to 2 new sections proposed for insertion by amendments numbers 8 and 9, rather than subject to subsection 5, the content of which will now be in a separate section if amendment number 9 is accepted. Amendment 7 deletes subsections 5 and 6, the content of which will be in the new, or the second new section. Amendment 6 is a drafting change that amends the subsection 4 of section 9 text to provide that the functions connected with the transferring land shall, after the transfer day, be performable by or on behalf of the City Council only, whereas the published version provides that the functions are performable by the City Council. Amendments numbers 8 and 9 create 2 additional sections, the first of which deals with the delayed transfer of land. Its purpose is to allow the Cork Local Authorities to agree that the transfer of certain land should not occur on the transfer day, which is the default position under section 9, but instead should happen at a later specified date. For drafting reasons, it was not possible to include the provision as an additional subsection due to associated performance functions and vesting of related choices in action provisions needing to apply from the deferred dates rather than the transfer day. Accordingly, the content of the new section is very similar to section 9 as proposed for amendment. This provision to enable the authorities to agree the deferral of some land transfers is proposed for inclusion in the bill at the suggestion of the Implementation Oversight Group. The associated Amendment 24 inserts into the published subsection 5 of section 12 an additional reference to the new section 10 that is proposed for insertion into the bill by this amendment number 8. The second new section created by amendment is number 9, and it deals with other agreements in relation to lands situated in the relevant area. Subsection 1 of which restates the content of the published subsection 5 of section 9, but also allows for the authorities to agree to share use of land transferred to the City Council under subsection 1 of section 9 and subsection 2 of which restates the content of the published subsection 6 of section 9. This material is being moved to a separate section for drafting reasons to facilitate the changes to the references in subsection 1 of section 9 that would be made by amendment number 5 if it's accepted. Amendment number 10 replaces subsection 1A of section 10 with 2 new paragraphs, the effect of which is to impose an earlier date than the transfer day of the 30th of April 2019, by which to make a designation and to require the local authorities to have regard to the implementation plan in so doing. This and the other changes contained in amendments numbers 12 and 13 arose from discussions with the implementation group on how section 10 should best operate in practice. Amendment 11 is a drafting change, changing the wording of subsection 1D that provides that the functions connected with the transferring property shall, after the transfer day and in relation to such property, be performable by or on behalf of the City Council only. Whereas the published versions provide that the functions are performable by the City Council. Amendment 12 inserts 2 new subsections 2 and 3, the first of which provides that the Oversight Committee may make a recommendation to the 2 local authorities that they should make a designation in relation to such property or property of such a class as may be specified in the recommendation. The new subsection requires the 2 authorities to notify the Oversight Committee of the making of a designation under Section 10. The non-receipt of a notification will trigger the Oversight Committee deciding whether or not to issue a recommendation under subsection 2. And if a recommendation is issued, would indicate that the recommendation will not, has not resulted in a designation being made. This is relevant to what would become subsection 4B if Amendment 13, proposing the insertion of a new subsection, is accepted. Amendment 13 replaces the existing subsection 2A with 2 new paragraphs. The first of these empowers the Minister to also make designations of property by order for the purposes of the Act, and the second provides that where the local authorities have failed to make a designation within a month of the Oversight Committee making a recommendation referred to in the preceding amendment, the Minister shall make the designation within the following 2 months. Amendment 14 is consequential and it inserts into the published paragraph B of subsection 2 a reference to the additional new preceding paragraph. Amendment 15 is a drafting change to the wording of subsection 2D to the same effect as Amendment 11, and it inserts a further subsection clarifying that multiple designations may be made under the section and may be made in respect of different property and different classes of property. In section 11, amendment number 18 inserts a new subsection before the current subsection 2 in section 11, similar to the current subsection 2 provision in relation to property, which will become subsection 3 if this amendment is accepted. This subsection is essentially repeating the subsection 1 paragraphs that apply in situations where land is transferred on a date or dates specified in agreement for the delayed transfer of land. Amendment 20 inserts a new subsection to clarify that the transfer of rights and liabilities arising by virtue of contracts or commitments includes those arising from development bonds that arise under the planning and development legislation. That's pretty much it for the time being, I think.
Minister? Donegan?
Maybe as relevant, I suppose it's relevant to 18 and 20. It might be as relevant to the next grouping, but look, I may as well raise it here. And just, I suppose, just to seek clarification, there's a lot of amendments here. My understanding of the position in relation to assets of transferring from the County Council to the City Council, obviously the asset transfer, generally speaking, that it wasn't always the case that any associated liabilities transfer across to the city. For example, I think the County Council were of the view that perhaps housing rental arrears, housing rent arrears mightn't necessarily follow. So I suppose if it's possible for, just to clarify, just maybe across a number of heads, where assets are transferring across, particularly, for example, rental arrears, where that stands, and generally speaking, is the liability transferring with assets to the City Council? There's a few other examples, housing loans, but I have a specific amendment on that, so we can deal with that separately maybe.
What we're allowing for, Deputy, is, and pretty much all of the transfers, that if the 2 councils between them reach agreement that for some reason an asset might transfer but the liability wouldn't, that can be the case under the legislation. But generally the provisions are such that if assets are transferring, liabilities are moving too, and that there has been some, and I think there's an amendment to that effect, and it might be in your name as well at some point, about the housing stock issue and the housing loans. But the view is that if the housing loans are transferring and that, income will accrue to the city potentially from that the liability should transfer also. Now we will be coming to that in your amendment. I was looking at it only earlier before I came in. I can't remember which one it is. But generally speaking, we're allowing the councils to opt out. Opt out might be the wrong terminology, but that if they agree between themselves that for some reason a liability shouldn't transfer when an asset is moving, that they can do that. But generally speaking, when assets are moving, that the liabilities will move with them.
Okay. And then just supplementary to that, so that's useful, but just, I suppose, both local authorities, perhaps not surprisingly, put forward the position at various stages that they should be indemnified against unexpected liabilities. And obviously, hard to indemnify both of them against that, but where there are unexpected liabilities, like, is that again by...
There's a catch-all section here.
Is that by agreement, or what way does the bill anticipate that work?
Indemnification against an unexpected liability, I suppose, the department cannot produce a blank cheque for any local authority in relation to that, but there are provisions that if a claim is submitted after the transfer date by a person who, say, who had a fall before the date on land owned by the county council, that the claim will be made against the city council. It also means that the city council will substitute for the county council in any contracts for services made by the county council before the transfer day that have not yet expired and relate exclusively to functions in the relevant area. If such a contract applies to functions performable in both the relevant area and part of the county council remaining within that authority's administrative area, the city council will become another party to the contract, and payments arising under the contract will have to be apportioned between the two authorities based on population. So essentially what that is saying, in effect, is in the first instance talking about somebody who's making a claim, an individual. If they are making a claim against the county council for a fall that occurred in the relevant area that's transferring, the claim will subsequently arise against the city council because the land is being transferred to the city council. But it also means that the city council will substitute for the county council in any contracts for services that are made by the council before transfer day but haven't been executed, I suppose is the proper word, before the transfer day.
They're related to the transition area?
Yeah. Yeah. The transfer area, I think, is what we're calling it, the grey area, some people call it. But
Okay.
That's fine.
we will come back to your amendment specifically later on.
It's very niche, but yeah. Okay, thanks.
Okay, so members, the question is Section 9, Amendment 5, that stand part of the bill. Is that agreed? Thank you. Section 9, Amendment 6, in the name of the Minister, already discussed with 5. Question is that amendment be made. Is that agreed?
Agreed.
Section 9, Amendment 7, in the name of the Minister, already discussed with 5. The question is that amendment be made. Is that agreed?
Agreed.
Question is that Section 9 as amended stand part of the bill. Is that agreed? Thank you. Section 10, Amendment 8, in the name of the Minister. It's a new section already discussed with 5. So the question is that the new section be there inserted. Is that agreed?
Agreed.
Section 10, Amendment 9, in the name of the Minister, new section already discussed with 5. Question is that the new section be there inserted. Is that agreed?
Agreed.
Thank you. Section 10, Amendment 10, already discussed with 5. Question is that amendment be made. Is that agreed?
Agreed.
Section 10, Amendment 11, already discussed with 5. Question is that amendment be made. Is that agreed?
Agreed.
Thank you. Section 10, Amendment 12, already discussed with 5. Question is that amendment be made. Is that agreed? Section 10, Amendment 13, already discussed with 5. Question is that amendment be made. Is that agreed? Section 10, Amendment 14, in the name of the Minister, already discussed with 5. Question is that amendment be made. Is that agreed?
Agreed.
Section 10, Amendment 15, in the name of the Minister, already discussed with 5. Question is that that amendment be made. Is that agreed? Thank you. So the question is Section 10 as amended stand part of the bill. Is that agreed? Thank you. Section 11, Amendment 16, in the name of the Minister, already discussed with 4. Question is that amendment be made. Is that agreed? Section 11, Amendment 17, already discussed with 4. Question is that amendment be made. Is that agreed?
Agreed.
Section 11, Amendment 18, already discussed with 5. Question is that amendment be made. Is that agreed?
Agreed.
Section 11, Amendment 19, already discussed with 4. Question is that amendment be made. Is that agreed?
Agreed.
Section 11, Amendment 20, already discussed with 5. Question is that amendment be made. Is that agreed?
Agreed.
Thank you. So the question is that Section 11 as amended stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 12, Amendment 21, in the name of the Minister, already discussed with 4. The question is that that amendment be made. Is that agreed?
Agreed.
Section 12, Amendment 22, in the name of the Minister, already discussed with 4. The question is that that amendment be made. Is that agreed?
Agreed.
Section 12, Amendment 23, in the name of the Minister, already discussed with 4. Question is that that amendment be made. Is that agreed?
Agreed.
Thank you. Section 12, Amendment 24, in the name of the Minister, already discussed with 5. The question is that that amendment be made. Is that agreed?
Agreed.
Thank you. So the question is that Section 12, as amended, stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 13, Amendment 25, in the name of the Minister, new section, already discussed with Amendment 1. Question is that the new section be there inserted. Is that agreed?
Agreed.
Thank you. Section 13, Amendment 26, in the name of the Minister, already discussed with Amendment 1. Question is that that amendment be made. Is that agreed?
Agreed.
Thank you. Section 13, Amendment 27, the name of the Minister, already discussed with 1. Question is that that amendment be made. Is that agreed?
Agreed.
Thank you. Section 13, Amendment 28, in the name of the Minister, already discussed with 1. The question is that that amendment be made. Is that agreed?
Agreed.
Thank you. So the question is, Section 13 as amended stand part of the bill. Is that agreed?
Agreed.
Thank you. So Section 14, Amendment 29, in the name of Mattie McGrath and Michael Collins, 29 to 35 inclusive are related and will be discussed together. Deputy Collins, do you wish to move?
Yes, indeed.
Do you wish to discuss?
No discussion, no.
No. Minister, do you wish to make comments on it?
Just to say, we don't propose to accept amendments 29 to 32 to section 14. It's about maps, essentially, and it would imposing a statutory requirement on the surveyor to deposit, and it's listed in the amendment. The term actually is to the principal office of all elected members of the council, a copy of each of the maps that are to be prepared under subsection 1. The issue we have, I suppose, is two or threefold. Principally that, or primarily that, there is no definition of the principal office of all elected members of the council, and it's not readily identifiable, and that it would place an unnecessary burden on the surveyor to ascertain where maps should be sent. But what has been done is that the maps will be available in both the City Council and the County Council offices, and available electronically on their websites also. I just feel that I think I understand what the Deputy is trying to propose, which is that the local authority members should have access to the maps of the area that they represent. But we feel that that is already the case in both local authority offices and electronically through the websites of both local authorities.
Is that amendment being pressed? No. You're withdrawing the amendment? Okay. So Section 14, Amendment 29 is being withdrawn. Section 14, Amendment 30, in the name of Deputy Collins and Deputy McGrath, already discussed with 29. Is that amendment being pressed?
No,
Is that being withdrawn?
it's been withdrawn, yeah.
Thank you. Section 14, Amendment 31, in the name of Deputy Collins and McGrath, already discussed with 29. Is that amendment being pressed?
No.
Is that being withdrawn?
Yeah.
Thank you. Section 14, Amendment 32, in names of Deputy McGrath and Collins, already discussed with 29. Is that amendment being pressed? No. Is it being withdrawn? Thank you. Section 14, Amendment 33, in the name of the Minister, already discussed with 29. The question is that that amendment be made. Is that agreed? Thank you. Section 14, Amendment 34, in the name of the Minister, already discussed with 29. The question is that that amendment be made. Is that agreed? Thank you. Section 14, Amendment 35, in the name of the Minister, already discussed with 29. The question is that that amendment be made. Is that agreed?
Agreed.
Thank you. The question is that Section 14, as amended, stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 15, Amendment 36 in the name of Deputy McGrath and Deputy Collins has been ruled out of order as potential charge on revenue. So Section 15, Amendment 37 in the name of the Minister. Amendments 37 and 58 to 63 inclusive are related and will be discussed together. You wish to move, Minister?
I wish to move. Amendment number 37 reverses the order of subsections 3 and 4 of Section 15 and inserts a new subsection 5 to provide that the Minister may perform any Oversight Committee functions specified under the Act after the Oversight Committee has been dissolved. The exception to this is the provision in Section 18 dealing with compliance with the Act, whereby the Oversight Committee may submit reports to the Minister on measures that they consider should be adopted to achieve compliance with the Act. Amendment 58, the purpose of which is to make Section 18 provision dealing with the making of arrangements by the two local authorities for the performance of functions optional rather than mandatory. And it's being proposed at the request of the implementation group, who do not consider that a mandatory provision is necessary. Other amendments that I'm proposing in this section are consequential to that change. There's the deletion by amendment number 60 of subsection 6, requiring the Minister to make an arrangement if the local authorities fail to do it, and the replacement of subsection 7, dealing with the amendment of arrangements made by the local authorities and made by the Minister, with a new subsection that simply provides that the Cork local authorities, after consultation with the Oversight Group, may amend or revoke an arrangement made under this section. And the deletion by amendment number 62 of subsection 10, providing that an agreement may not be revoked without the Minister's consent, which is now superfluous. Amendment 59 is a technical drafting change to remove superfluous text in subsection 3A. Amendment 63 is also a drafting change to the order of the wording of the provision in subsection 11.
Thank you, Minister. Any questions to the Minister? No? Okay, so Section 15, Amendment 37. The question is that amendment be made. Is that agreed?
Agreed.
Thank you. So Section 15 as amended, so the question is, Section 15 as amended stand part of the bill. Is that agreed? Thank you. Section 16, Amendment 38 in the name of Deputy McGrath, Deputy Collins. 38 to 44 inclusive, 46 to 50 inclusive, 52 to 57 inclusive, and 69 to 72 inclusive are related. 49 is a physical alternative to 48. 53 is a logical alternative to 53 is a logical alternative to 52. 55 is a consequential of 54. 38 to 44 inclusive, 46 to 50 inclusive, 52 to 57 inclusive, and 69 to 72 inclusive, and will be discussed together. You wish to move, Deputy Collins?
Yes.
Wish to press?
Yes.
Do you wish to discuss?
Let others there want to discuss it to start with. I'm okay for now.
You're okay. Minister, do you want to make any comments?
Well, there's a list and a broad list of topics in subsection 2 of section 16 that might be possibly covered in the implementation plan. So it would be appropriate to make the specification of all of them mandatory and remove elements of discretion from the Oversight Committee as to what should be included. The plan will be very much influenced by the work that's ongoing between the Cork Implementation Group, which is the precursor to the Statutory Oversight Committee, and the two local authorities. So I oppose the removal of the committee's discretion that is implicit in amendment number 38, which is substituting the word may for the word shall.
Deputy Collins, you wish to press?
Yes, I'll press.
Okay. So the question is that the Section 16, Amendment 38, that the amendment is made. Those in favour say thaw.
Thaw.
Those against say Neil. Neil. So the question is lost. Thank you. So Section 16, Amendment 39, in the name of the Minister, already discussed with 38. The question.
Sorry, yeah,
Sorry.
no, I indicated, I thought, yeah, this is a big grouping and I have a few there, so it's at this stage that I should be speaking to them, isn't it?
It is, before we move on to the next one, yes.
Yeah, no, sorry, because I indicated. There's a few, which is, I suppose, firstly the amendments to section 17, and I suppose the difficulty for me is that you propose to delete section 17 now. if I'm correct in saying that, and substitute it with some sections that deal with a lot of that stuff elsewhere. So I suppose if it's going to be deleted, I'm not sure there's much point in amending it. But in any event, I suppose to make the general points in relation to it. Firstly, I have Amendment 46 and 47 and 49, which are all related, and 49 and 48 are quite similar in some respects. Like, I mean, in all my contributions to this, I've been conscious to ensure that both local authorities are as financially sustainable as possible. There is a strong belief in Cork County Council that there needs to be some kind of commitment to an ongoing settlement and an ongoing, that this isn't something that should disappear after 10 years or 15 years. That needn't necessarily be as rigid as the position that might exist for the first 10 years. But I think it's fair that there should be some kind of ongoing commitment, subject to review and negotiation. But I don't know that there should be a deadline set on that. There's also a view that the base amount, like, I mean, I suppose that component of the financial settlement that's outside of perhaps transfers assets and offsetting liabilities, development contributions, so on, the base amount that's, I suppose, being paid from the city to the county, or I'm confused myself now. Yes, that is being paid from the city to the county. That should be index linked up and down, but that it would be fair that that be index linked rather than. I think the bill at the minute allows for quite a level of flexibility in relation to that, which could make life difficult for the county council if they cannot rely on that. And there's also a view that there is a need for some degree of certainty in relation to frequency of payments, and that's the basis for 49 on Deputy Collins' amendment. Similarly, 48, that the financial settlement should be paid on an advanced monthly scheduled basis, so that the county council has some sense of being able to account for this on a frequent enough basis. In addition, I have Amendment 53. There was some view that, I suppose this is kind of a compromise proposal, that the existing position is not later than 3 years. There was a fear in the County Council that that might start quite a bit earlier than 3 years. So what I've proposed is that it starts exactly within 3 years of the transition, to be completed within 6 months. I'm not proposing, there is some suggestion of that the second review should be pushed out beyond 10 years. I don't think that that's right. I think 10 years is a reasonable interval for that second review, but I think it's a fair compromise of 53 to say exactly 3 years. It should begin May 2022 and completed within 6 months. And then, again, 56 is similar to the point I've made already in relation to subject to revising and renegotiation. I think there should be some level of reliance on that. I also just on 69 and 72 just have 1 or 2 points, if you don't mind. Now, I suppose just in relation to that set, they're also section 17. The Minister's proposing to do things differently. I can probably live with that and return to this at report stage, but I would like some reassurances on the general points that I've made there before considering what position I take. In relation to 69, the point has been made there in relation to subsection 6 of it, and it appears in a few places. Now, I think I can understand this in relation to there is an effort, I think, there is a concern that two local authorities don't want to end up in the courts against each other trying to settle any financial differences that exist. There seems to be in a lot of the amendments an effort to try and address that by way of ministerial intervention, reference to the oversight group, so on. But in a number of places, including at the end of subsection 6 here, it does retain that part of that contribution, or that part of the contribution which remains unpaid, shall be recoverable by the City Council in any contempt of court. or in any court of competent jurisdiction, as a simple contract debt. So I suppose to ask there is there any, like, I mean, is that absolutely necessary? I know that there is provisions now for ministerial intervention, but, like, I mean, is it absolutely necessary to have a provision that, you know, still anticipates both local authorities in a courtroom situation against each other? Like, I mean, that's obviously, you would hope that both local authorities don't end up in that situation, but is it absolutely necessary to have that provision there? And then in the same section, I've only 2 more points, Chair, so apologies. Sorry, subsection 1 of 20 there. The payment for 2019, I'd be a little concerned by the fact that the County Council has until April 2020 to pay for that. Like, could it end up that you have a situation towards the end of 2019 that the City Council is thin on finance for the area that's being transitioned, and it's waiting until April 2020 to receive payment of that? Now, obviously, you'd hope that they pay before that, but they're still being given that latitude. Like, I'm not sure that that's wise. I would have a little concern in relation to that. And then, finally, 72, just to clarify that it remains the situation, just ask, I think the new section 23(4), I think in part relates to development contributions. Is it still the case that development contributions that are related to a development in the transition area, that those development contributions go to the City Council?
Yes.
That remains the case? Okay, all right, great. You can get on with the many other things.
I have about a 17-page explanation. I'll try to distill some of the points. The reason we're changing the numbering and the ordering, we're inserting a new part 3 dealing with financial arrangements consequent upon the boundary alteration, and that is why it involves replacing section 17, and that's the purpose of why we're doing that. There is a provision, and I'll try to get the exact reference to it, that, for indexation, and I suppose the time value of money when I learnt it, but I'll give it to you when I find it. Essentially, the contract debt, we have made an effort to remove any potential routes for litigation, but it's a precautionary thing and it's a legal thing. There has to be some, I suppose, bottom line, and we've tried to minimise the amount of mentions of it, if you like. It's like a backstop, to use a hackneyed phrase. The contract debt, there has to be a final means by which it can be recovered, I suppose, and it isn't our intention that, and we've made every effort to remove it, but it is still included in that part. In relation to the review after 3 years, it's gone. It's been removed. A direct response to the second stage contributions, which many of the members here would have made, spoke about the potential impact of a review after 3 years, and what we're saying now is after 10 years, the City Council can effectively communicate with the Minister of the Day the reasons as to which they believe that the compensation should either be removed or examined again, reduced. And it'll be up to the Minister of the Day to make that particular call. I mean, it is the case that in Galway, when Galway City was established as a separate authority in 1985, there are still payments being made by Galway City to Galway County on a compensatory basis, whatever that is, 33 or 4 years later. But it was felt that, as you said yourself, a review after 10, or mechanism at 10 years for an application made to vary or to drop the compensatory package was probably a fair balance between the original provision to look the possibility of looking at it after 3 years, and indeed whether it would be stretched out further. The reason, and you referenced this, we've allowed flexibility for the City Council to make the 2019 payments up to April of 2020, is that the calculation, there's a lot of change going to happen in Cork City Council in the next 6 or 8 months, and they will need a bigger window than the normal calendar year to calculate, first of all, and then to make the payment. It's just an attempt, I suppose, by the officials in the Customs House to realise with difficulties that local officials will have in reaching that calculation. In terms of indexation...
That specific payment, if I'm understanding it right, relates to the expenditure that's now being spent by the County Council in the area. So that's actually a payment from county to city, if I'm right.
Which one? Oh, yeah, okay. I got my city and county mixed up. The other, I'll be doing that a lot, I would expect. In relation to indexation, section 22, subsection 12, the definition of an annual contribution. It's going to be in the new subsection or 12 of section 22, which is being amended by amendment number 40. Which basically allows for an indexation value to be placed on the compensation. So that is included. I think I've dealt with a lot of the questions you.
Yeah,
sorry, Chair.
Most, but not quite all. I suppose the 2020 thing isn't quite explained because we were visualising it the other way around. So I'm not sure the County Council needs that flexibility. So maybe just to ask in relation to that. And then, I suppose I'm not quite sure I agree with getting rid of the 3-year one. Like, I mean, I think what I proposed was a reasonable balance. But, like, I mean, if the calculation is somehow or other drastically wrong or disadvantageous to the City Council, I think it's reasonable to wait 3 years for a first review. But, like, I mean, I think you could end up to leave that 10 years without reconsidering it. Could be if it's got wrong. I'm not sure that that's fair. And then finally, just on the other hand, is that point that I made. There should be an ongoing commitment, and like beyond the 10 years. Like, does the Minister believe that exists within this legislation? I think we need to have, the County Council has to have some sense that this will continue beyond that.
It does exist. And it will be at the discretion of the City Council to make the application to seek to change or to vary. But it will be the Minister and the Department who will make the ultimate call as to the extent of variation that they will deem to be fair at that 10-year point. What is also included in the amendments that are proposed here is much more detailed, line-by-line outlining of expenditure heads. So it is believed, hoped, held by the department that that won't allow for, I suppose, any unforeseen costs kind of emerging or any unforeseen expenses. And that was the purpose of a number of the amendments that are proposed to this particular section. But the issue in relation to the council, the county, and that extra window, I suppose it's the same as in reverse. Earlier on that I was speaking, that because of the change there's still certainty in the sense that the city will know that the funding is coming, and ultimately the city can go, because it can go to the courts if it goes that far in terms of getting funding or getting the funding fully paid. But it was felt that to have it all included within the calendar year would potentially place too much of a restriction. But it isn't envisaged that it will be allowed drag, on indefinitely. It's just placing a looser timeline on the payment of that particular contribution.
Any further questions? No.
I wasn't sure if I heard the Minister correctly. That the Cork City Boundary Agreement has a backstop. I think we should have been told.
Michael, did you want to say anything there?
It's all Cork, you see. It's all Cork.
No. Okay. Well, sorry. No. We're not. 48, you can, yeah. 38. You've already done, and we've already moved that amendment.
Okay, that's fine.
Is that all right?
Okay.
Okay. So section 16, amendment 39 in the name of the minister, already discussed with 38.
Agreed.
Questions that amendment be made. Is that agreed? Thank you. Section 16, amendment 40 in the name of the minister, already discussed with 38. Questions that amendment be made. Is that agreed? Section 16, amendment 41 in the name of the minister, already discussed with amendment 38. Question is that amendment be made. Is that agreed?
Agreed.
Thank you. Section 16, amendment 42 in the name of Deputy McGrath and Deputy Collins, already discussed with 38. Deputy Collins, are you pressing that amendment?
Yes.
Yep. So the question is that, the question is on amendment 42, is that that amendment be made. Those in favour say Tá.
Tá.
Those against say Neil. Neil. The question is lost. Section 16, amendment 42, in the name of the minister, already discussed with 38. The question is that amendment be made. Is that agreed? Sorry.
43.
Sorry, 43. Bingo.
Agreed.
Section 16, amendment 43, already discussed. Question is that amendment be made. Is that agreed? Thank you. Section 16, amendment 44, in the name of the minister, already discussed with 38. Question is that amendment be made. Is that agreed?
Agreed.
Thank you. So the question is section 16 as amended, stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 17, amendment 45, in the name of Deputy Collins, is being ruled out of order as potential charge on the revenue. So section 17, amendment 46, in the name of Deputy O'Brien, Deputy O'Leary, Deputy O'Brien and Deputy Buckley, already discussed with 38. Is that amendment being pressed?
Not pressed.
You're withdrawing that amendment?
Yeah.
Thank you. Section 17, Amendment 47, in the name of O'Brien, O'Leary, O'Brien and Buckley, already discussed with 38. Is that amendment being pressed?
Not pressed.
Been withdrawn?
Yeah.
Thank you. Section 17, Amendment 48, in the name of Deputy Collins, already discussed with 38. Just to note that if this amendment is passed, 49 can't be moved. So the question is this amendment being pressed?
Yes.
Yeah. So on Amendment 48, the question is that the amendment be made. Those in favour say Tá.
Tá.
Those against say Neil.
You.
The question is lost. Section 17, Amendment 49, in the name of Deputy O'Brien, O'Leary, O'Brien and Buckley, already discussed with 38. Is that amendment being pressed?
It's the same as 48, so if that's defeated, I suppose I withdraw it, and in the context of 17 be deleted. But a point I hadn't actually got a response on the minister, should just take into account and not open it up to debate again, is that advance monthly, the scheduled payment. So if you take it into account for report stage, please. Okay. And I'm happy to withdraw that in the meantime.
Okay. We have discussed it already.
I may reintroduce a report. Yeah.
Great, that's okay. So section 17, amendment 50, in the name of Deputy Collins, already discussed with 38. Is that amendment being pressed? Okay. Question is on amendment 38, that amendment be made. Those in favour say Tá.
Tá.
Those against say Neil. Neil. Yeah. That amendment is lost. Section 17, Amendment 51, in the name of Deputy Collins, has been ruled out of order as it's in conflict with the bill as read a second time. Section 17, Amendment 52, in the name of Deputy Collins, already discussed with 38. And just to note that if the question on 52 is agreed, 53 cannot be moved. So, Deputy Collins, is that amendment being pressed?
Yes, indeed.
Okay. So the question is that on Amendment 52, that the amendment be made. Those in favour say Tá.
Tá.
Those against say Neil. Yeah, the amendment is lost. Section 17, Amendment 53, in the names of Deputy O'Brien, O'Leary, O'Brien and Buckley, already discussed with 38. Is that amendment being pressed?
Withdrawn.
That amendment's been withdrawn. Thank you. Section 17, Amendment 54, in the names of Deputy McGrath and Deputy Collins, already discussed with 38. And just to note that if the question of 54 is negatived, 55 cannot be moved. So, Deputy Collins, is that amendment being pressed?
Yes, it is being pressed, yeah.
Okay, so the question is on Amendment 54 that amendment be made. Those in favour say Tá.
Tá.
Those against say Neil. The amendment is lost. I can't. Section 17, Amendment 56, in the name of Deputy O'Brien, O'Leary, O'Brien and Buckley, already discussed with 38. Is that amendment being pressed?
Withdrawn.
Withdrawn, thank you. Section 17, Amendment 57, in the name of Deputy Collins, already discussed with 38. Is that amendment being pressed?
Yes, indeed.
Okay, so the question is that Amendment 57, that amendment be made. Those in favour say Tá.
Tá.
Those against say Níl. Question is lost. Deleted. Okay, so a question is that Section 17 be deleted from the bill. Is that agreed? In the name of the Minister.
Yes. Agreed.
Thank you.
Yeah.
Section 18, Amendment number 58, in the name of the Minister, already discussed with 37. Has that been moved?
Yes.
The question is that amendment be made. Thank
Agreed.
you. Section 18, Amendment 59, already discussed with 37. The question is that amendment be made.
Agreed.
Section 18, Amendment 60, in the name of the Minister, already discussed with 37. The question is that amendment be made. Is that agreed?
Agreed.
Section 18, Amendment 61, already discussed with 37. Question is that amendment be made.
Agreed.
Section 18, Amendment 62, already discussed with 37. Question is that amendment be made. Section 18, Amendment 63, in the name of the Minister, already discussed with 37. Question is that amendment be made. So the question is that Section 18, as amended, stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 19, Amendment 64, in the name of the Minister, already discussed with Amendment 4. Question is that amendment be made.
Agreed.
Section 19, Amendment 65, in the name of the Minister. 65, 67 and 68 are related and will be discussed together. Minister, you wish to move?
Yes, I wish to move. Amendment 65 amends the published section 19 by inserting an additional item to subsection 3. Actions that the chief executives are required to carry out for the effect and orderly operation of the Act, namely to cooperate with one another to ensure compliance with the implementation plan. I'm proposing that this amendment, in response to a suggestion made by the Oversight Group in Cork. Amendment 67 deletes and replaces the published subsection 9, requiring the two chief executives to provide the Minister with any requested information, with a new subsection containing 2 paragraphs that separately require the Chief Executive of the City Council and the Chief Executive of the County Council to provide the Minister with any requested information within the specified period in the request, and that the Minister seeks for the purpose of his or her functions under the Act. The additional new subsection 10 proposed for insertion by Amendment 68 provides similarly for the provision of information requested by the Oversight Committee from the Chief Executive of the City Council and the Chief Executive of the County Council.
Any comments? No? Okay. So the question is Section 19, Amendment 65, in the name of the Minister, that amendment be made. Is that agreed?
Agreed.
Thank you. Section 19, Amendment 66, in the name of the Minister, already discussed with Amendment 4. Question is that amendment be made.
Agreed.
Section 19, Amendment 67, already discussed with 65. Question is that amendment be made.
Agreed.
Thank you. Section 19, Amendment 68, in the name of the Minister, already discussed with 65. Question is that amendment be made. Is that agreed? Thank you. So the question is that Section 19, as amended, stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 20, Amendment 69, in the name of the Minister, new section, already discussed with 38. The question is that the new section be there inserted. Is that agreed?
Agreed.
Thank you. Section 20, Amendment 70, in the name of the Minister, new section, already discussed with 38. That the new section, the question is that the new section be there inserted. Is that agreed?
Agreed.
Section 20, Amendment 71, in the name of the Minister, new section, already discussed with 38. The question is that the new section be there inserted. Is that agreed?
Agreed.
Thank you. Section 20, Amendment 72, new section, already discussed with Amendment 38. Question is that the new section be there inserted. Is that agreed?
Agreed.
Thank you. So the question is that Section 20 stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 21, Amendment 73, in the name of the Minister, already discussed with 4. Question is that amendment be made.
Agreed.
Question is that Section 21, as amended, stand part of the bill. Is that agreed?
Agreed.
Section 22.
Yeah.
Section 22, Amendment 74, in the name of the Minister. To move?
Yes.
Yep.
Carla, I want to move 74, which inserts an additional subsection 3 into section 22 for the purpose of which is to provide that the relevant area is to be deemed part of the administrative area of Cork City Council for the purpose of the performance by the Minister of his functions under Part 4 of the Local Government Act 2001 when making the orders to divide Cork City and Cork County into local electoral areas for the 2019 local elections.
Any comments? No? Okay, so the question is, Section 22, Amendment 74, that amendment be made?
Agreed.
Question is, Section 22 as amended stand part of the bill. Is that agreed?
Can I raise
Sorry.
an issue at this point?
Yep.
The objective, obviously, at this stage is to get this piece of legislation passed by both houses of the Oireachtas before the Christmas recess. And that will require a lot of things to happen in unison, I suppose, over the course of the next few weeks. It is necessary for me, I suppose, to highlight to the committee at this stage that doesn't happen. I may need to introduce an amendment at report stage, which I have to make reference to at committee stage, to change the necessary time allocated and to change the published Part 3 or Part 4 of the bill to provide for later dates for the publication and the coming into force of the Register of Electors for the 2 Cork local authorities than those that are specified for all local authorities under the 1992 Electoral Act. So there may need to be a specific extension of the time period. It's a technical thing. It's not any. It's allowing the Cork local authorities, if we don't get our work done in time, that amendment can be introduced at report stage.
Okay. Owen?
Or is that dependent on when the bill completes all stages?
It's dependent on when the bill completes all stages.
So it would be a matter of days or weeks. It wouldn't be beyond that.
You're talking about maybe a month or 6 weeks. Yeah.
Okay, so the question is that Section 22 as amended stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 23, Amendment 75, in the name of the Minister or discussed with 4. Question is that amendment be made.
Agreed.
Section 23, Amendment 76, in the name of the Minister or discussed with 4. Question is that amendment be made.
Agreed.
The question is that Section 23 as amended stand part of the bill. Is that agreed?
Agreed.
Section 24, Amendment 77, in the name of the Minister. Just to let members know, acceptance of this amendment involves the deletion of Section 24 of the bill. This is a new section, so Amendments 77 to 79 inclusive, 81 to 83 inclusive, 100 and 103 are related and will be discussed together. You wish to move, Minister?
Yes, Ciara, these are in relation to development plans and local area plans. Move Amendment 77, which provides for the replacement of Section 24 with a new section now to be headed development plans relating to the relevant area, which is a restatement of the published Section 24, but expanded to include the local economic community plans, which I think was touched on again in second stage by a number of the speakers. Subsection 1 provides that Cork County Council development plan applicable to the relevant area before transfer day will remain in force in that area until Cork City Council makes a new development plan after transfer day. Subsection 2 provides that any local area plan in force before transfer day in respect of an area within the relevant area will continue to apply until Cork City Council next makes a local area plan for that area. Subsection 3 provides that the Cork County Council local economic and community plan in force before the transfer day will continue to apply to the relevant area until Cork City Council next makes its own local economic community plan. Subsection 4 is an avoidance of doubt provision clarifying that Cork City Council may vary the development plan or amend or revoke the local area plan that were continue to be in operation under the previous subsections, but only insofar as the plan applies to the relevant area. The City Council may also perform functions in relation to monitoring and reviewing of economic elements of the Cork County LECP and reporting on that assessment, but only again insofar as it applies to the relevant area. Subsection 5 defines the development plan and local area plan as having the meanings assigned in the Planning and Development Act 2000. Amendment 78 deletes the words permission granted or from subsection 1 of section 25, so as to clarify that the subsection is only intended to provide for a continuing role for the County Council in processing planning applications made before transfer day to the point where a decision is made to grant or refuse the application. Amendment 79 deletes the published subsection 2A and replaces it with a new subsection 2A to clarify that after the transfer day, the City Council becomes the planning authority for any planning applications decided or any appeals to onboard Penala determined before transfer day, apart from cases where enforcement proceedings had already been commenced by the County Council. Amendment 81 amends subsection 2B by inserting a requirement for the County Council to consult the City Council when finishing out enforcement proceeding cases that had already commenced before transfer day. Amendment 82 replaces subsection 3 with a new subsection 3 that removes the reference to contributions paid under section 48 of the Planning and Development Act 2000 from the provision. This change is made subsequent to information received from the County Council that isolation of contributions in respect of public infrastructure and facilities benefiting development in the area of the planning authority as a whole, paid and not yet expended in the case of developments in the relevant area, would not be possible. The provision therefore now just deals with section 49 contributions that will vest in the City Council, in other words earmarked contributions for specific projects, and will continue to require to be expended on public infrastructure services and projects in the relevant area. The final amendment to section 25, which is number 83, adds development to the terms defined as having the meaning assigned again by the Planning and Development Act 2000 in subsection 5. The new section introduced by Amendment 100 proposes to insert after subsection 30 dealing with the making and review of development plans for the Cork local authorities, the purpose of which is to enable the Minister to extend by order the statutory time limits applicable to the development planning process. The new section amends sections 9 and 11 of the Planning and Development Act 2000 to enable the Minister by order to add an additional period of no more than 1 year to the normal 6-year period within which the City Council and the County Council must make their development plans, and to provide similarly in relation to the 4-year period applicable to the giving of notice of an intention to review the development plan. The new section 32 proposed by Opposition Amendment 103 involving the amendment of section 13 of the Planning and Development Amendment Act 2018 is, I imagine, for the same purpose as Government Amendment number 100, which I just discussed. So I hope that the deputies can take that into consideration if they're considering their own amendment number 100 and 103.
Thanks, John Paul. Duncan?
You might actually repeat that for me, sorry, maybe in just response to this, because I was just beginning to look at my own notes there.
Our amendment number 100 effectively is doing the same thing that your amendment number 103 is seeking to do.
Okay.
This is all about the applicability of development plans and local area plans, and how the transfer arrangement will impact on the applicability of those plans in the relevant area until a new plan is drawn up.
Okay. I suppose it's not quite the same thing. Maybe it addresses it all the same. Look, I'll address those two, but I just have another point before maybe I come to my own amendment. Just a question there, and it's relevant to the grouping as a whole. Part 8, what happens to a Part 8 process that is started before the transition date? For every likelihood, the County Council or the City Council may not proceed and to avoid that, but is it foreseen what happens to Part 8 processes that are either span the transition or are completed shortly beforehand? So just in terms of that, because we need to ensure that projects initiated by the County Council continue to flow smoothly into the City Council as best as possible. So always that anticipated. Just my own 2 amendments there. I'll deal with 103 first. That's specifically the point is made by the City Council that the regional spatial and economic strategies are due to be adopted in March 2019. under, I think, the Planning and Development Acts, the City Council is generally required to start the process of a new city plan within 13 weeks of that, but that will be June 2019, which will be, they'll be a small bit busy. So I think a bit of flexibility there would be reasonable. So, like, I mean, if that's covered, fair enough, but I'm not quite sure that it is from the explanation that you've given. The other one then, 102, and I've discussed this with you previously, like I, as a councillor for one of the largest transition parts, like I had the experience of working in a municipal district and having been sceptical at the outset. And to be honest, the experience of councillors in different municipal districts was different, but we had a very good municipal district. It worked very well. It kept local issues off the county council agenda, ensured they were dealt with at a local area. I think it's a good model. I know that there are area committees in Dublin and in other places, but they don't have the same statutory basis. Right, I appreciate that perhaps it may not be in order for full local area plans to be made by municipal districts in a city such as Cork, although maybe there is a value in it. But municipal districts can make bylaws, and I think that that does make sense to do that at a more local level. It does make sense for municipal districts to adopt or comment upon the municipal allocation or the budgetary allocation that's coming down from the City Council. I think all those things make sense, and if you provide that statutory structure for dealing with the very local issues, but also taking very local budgetary initiatives, I think that that will be of value to those councillors in that ward or in that municipal district, but it also will ensure that the City Council as a whole is far more focused on the overall policy and direction and strategy of the city and the metropolitan area. So I think it's a good model. I think we should have it in the city or something like it.
In relation to the Part 8's question, it comes in under enforcement and actually section 25(2)(b, and the Part 8 process will stay with the County Council until it has been completed, and then it will continue on and move, I suppose, with the relevant area into the City Council can continue on. You can take up where the County Council has left off. Effectively, it doesn't drop or disappear, or it will be finished by the County Council until the process is completed.
Is that does that anticipate just a formal legal process, or?
That's the formal legal. That you know yourself with Part 8s, process can take a while. Rather than getting the City Council to start the ball rolling from scratch again, the County Council will complete the formal legal process. But then it's a matter of part of the transfer then for the City Council to, I suppose, implement whatever the Part 8 is. Sure. Our amendment number 100 takes account at least partially of what you were saying, I think, in relation to your amendment number 103.
Yeah.
We're going to allow the Minister the discretion, if asked by the local authorities, to grant a time period of up to 12 months of an extension to the existing development plan to allow for the drafting of the new development plan. That's not to say that it's necessarily it's up to 12 months if it's sought. So it's just again to provide a window for the planners and for the councillors considering it that they can actually do the thorough work that's involved in drafting county development plans. In relation to the municipal districts, in city authorities around in Ireland, the municipal district structure doesn't exist, and I understand the points you're making in the broader context about municipal districts. They vary, their impact and their effectiveness varies greatly from local authority to local authority. Some local authorities have very well embedded, supported, funded municipal districts that operate very successfully. In some local authorities the structure is still weak, and a lot of the issues that you were talking about that should be dealt with at local district level end up going back into the full plenary session of the council, and that is a matter that we will have to return to probably in the future. It is open to Cork City Council, as it is with Dublin City Council, to designate area committees. Now, they do not have the same powers and functions. But I suppose one of the purposes of doing this all of these sections of the bill relate to Cork specifically, and a decision was taken that to provide for the proper planning and development of Cork into the future, that we should look at Cork City as one entity rather than the current system where, you know, bits of it are in certain municipal districts in the county, different municipal districts with different local area plans, and that there should be one plan for the city of Cork. Now, whether in the future different constituent parts of what will be the new city, I mean, there are strong identities in some of the areas that you would have represented and are from on the south side, as they are on the north side of Cork City, like urban villages effectively that were in County Cork up till now but will now be in Cork City. There's a particular issue, I suppose, in relation to Ballincollig, which has traditionally been separate, but through continuous development over the years, Cork City has just spread to Ballincollig, and it would be impossible for anyone here to envisage a Cork City in 20 years that Ballincollig wouldn't really be an integral part of. Now, whether, and I will have to talk to maybe my colleague Damien English about the provisions in relation to local area plans, separate local area plans for some, like the likes of that, which is is a very identifiable component of the new Cork City, the new extended Cork City. Like, I'd certainly be willing to talk to him before the report stage about if there's some leeway that can be made in the Planning and Development Act that would allow for a more local-based area plan for specific parts of the newly constituted Cork City. So maybe leave it with me, I would say, until report stage if you can, Deputy. I'll talk to Minister English to see if it can be included. Maybe it can't, but...
Okay. I will. I'm encouraged by that. But I would also add, it's not just the planning elements, it's the bylaws and the budgetary stuff too. And the statutory structure. I know there's area committees in Dublin that work pretty well. There's no statutory structure for it. I think we need to look at that. So I'd be obliged if you can return to that anyway. Our report says.
Okay, so Section 24, Amendment 77, in the name of the Minister, new section, that the question is that the new section be there inserted. Is that agreed?
Agreed.
So the question is that Section 24 be deleted from the bill. Is that agreed?
Agreed.
Thank you. Section 25, Amendment 78, in the name of the Minister, already discussed with 77. The question is the amendment be made. Is that agreed?
Agreed.
Section 25, Amendment 79, already discussed with 77. Question is that the amendment be made. Is that agreed?
Agreed.
Thank you. Section 25, Amendment 80, in the name of the Minister, already discussed with Amendment 4. Question is that the amendment be made. Is that agreed?
Agreed.
Section 25, Amendment 81, in the name of the Minister, already discussed with 77. Question is that the amendment be made. Is that agreed? Thank you. Section 25, Amendment 82, already discussed with 77. Question is that the amendment be made. Is that agreed? Thank you. Section 25, Amendment 83, already discussed with Amendment 77. Question is that the amendment be made. Is that agreed?
Agreed.
Thank you. The question is that Section 25, as amended, stand part of the bill. Is that agreed?
Agreed.
Thank you. Section 26, Amendment 84, in the name of the Minister, already discussed with Amendment 4. The question is that the amendment be made. Is that agreed?
Agreed.
Section 26, Amendment 85, in the name of the Minister, already discussed with Amendment 4. The question is that that amendment be made. Is that agreed?
Agreed.
Section 26, Amendment 86, in the name of the Minister, already discussed with Amendment 4. Question is that that amendment be made. Is that agreed?
Agreed.
The question is that Section 26, as amended, stand part of the bill. Is that agreed?
Agreed.
Section 27, there's no amendment, so the question is that Section 27 stand part of the bill. Is that agreed?
Agreed.
Section 28, Amendment 87, in the name of the Minister, 87 to 89 are inclusive and 91 are related and will be discussed together. Minister, you wish to move?
Yes, I move Amendment 87. It replaces, seeks to replace subsection 1 of Section 28. It's mainly a drafting change, and it also allows for the two local authorities to agree an alternative to the default position whereby existing arrears of the main revenue sources are remaining payable to the County Council if such an agreed alternative suits them. Similarly, Amendment 88 again allows the two local authorities to agree an alternative to the default position whereby the main revenue sources remain payable to the County Council in respect of all of 2019 if such an alternative suits the two local authorities. Again, amendment number 89 inserts a new paragraph B into subsection 3 to include entry year property levy within the provision. That's my three amendments.
And 91?
91 is whose amendment? Yeah. I understand, as I understand Amendment 91, its purpose is for the mortgage debt. This is what we were discussing earlier, of the housing loan recipients in the relevant area, and the associated loan repayments to remain with the County Council. I don't propose to accept it, as the normal arrangement that applies to a boundary alteration is that the housing loans and all associated management of those files will transfer across to the new local authority, in this case the City Council. It's the City Council that will receive the subsequent repayments and will also deal with any consents to resale that might arise in the future. And the bill provides that assets and liabilities will transfer to the City Council on the transfer day, and that repayments are payable to the City Council from the 1st of January of the following year. Liability owed to the HFA, the Housing Finance Agency, associated with the mortgages on the properties will transfer from the county to the city, as will the income stream, which will offset the debt owing to the HFA. So there's not going to be any, in effect, really not going to be any change to the terms or tenure of the mortgage holders, and it would be unusual, I suppose, to change the position that, well as transferring the assets, that you wouldn't transfer the liability. So in that instance, I'll be opposing Amendment 91.
Donnacha, no, that's your amendment, is 91. Do you want to discuss?
Yeah, sure. I suppose it's not. I suppose it's different to local authority housing or some of the other issues. That, like, I mean, the asset is the liability, like in the sense that, you know, it's the loan. There is a substantial amount of, I think there's approximately 150 of these properties in the transition areas. It's not a huge amount, but there is a concern that the level of administration that would be involved in the transfer of those from the county to the city would involve proportionately a significant amount of work for the city. It would actually be far easier to just let it with the county. Like like, I mean, there's a number of questions there, like all the transactional data will have to come across. The county council have to provide the city with complete paper files. There have to be a risk profile. There may be legal proceedings on foot of some of the county council. The county council may have initiated legal proceedings in relation to some of those borrowers potentially. There would be changes to statutory reporting requirements to Central Credit Register, and then there's the question of loan accounts and credit. So, like, I mean, well, I think the general approach that's being taken makes some sense, albeit I would add that I would hope that the department will consider resources for a lot of these issues, for the administration of them. I think the housing loans are a particular category, and I'm not sure they're properly categorised as an asset, really, to the council.
Well, in accounting reason they are. I understand the point you're making, and like you're saying that it's not a huge amount of housing loans, but so the purpose, or my answer is that we want to make the clean break, and it would be very messy if these remain still in with the county council, even though they're in the transfer area, the relevant area that's being transferred to the city. I don't dispute that it may take up extra man hours, and we are providing additional substantial resources to both local authorities for the changeover period. But I don't think because the process itself might be difficult is sufficient reason to make an exception for housing loans. I think it would it's clearer and cleaner if the transfer includes them. I don't understand the issues you're raising, but I think it should happen.
Any further comments?
Yeah, look, I mean, I suppose I suppose maybe just to clarify the point and just to leave the Minister with this, and maybe if he wants to communicate with the local authority in relation to it. I suppose the point is that it might be like the difficulties that would be involved in the transfer of them. There's very little difficulty, as far as I can see, in leaving them with the County Council. Like, I mean, it's a contractual obligation with the Council, but there's no obligation in terms of housing maintenance, tenancy, anything like that. It's a simple contractual arrangement. So look, if the Minister would take that into account, perhaps in advance of report stage, then I might return to him. And if you could communicate with the City Council.
I don't think I can take it on board, to be honest. I don't like saying no. I'm a real politician, I suppose, but you know, we're devising the main purpose of all of these sections of the Act is to expand Cork City. I just think it wouldn't be consistent with what we're trying to do to allow these to remain, you know, as part of the with the County Council, even though they will be physically in the city in the future. I just think it's a cleaner thing, and I can't accept it. And I have enough to be doing to talk now. I'm going to talk about the other couple of amendments, and I will talk about others in the future. But I think this one is just a messy one. That's all.
So the section 28, amendment 87 in the name of the Minister. Question is that amendment be made? Thank you. Section 28, amendment 88 in the name of the Minister. Already discussed with 87.
Agreed.
Question is amendment made. Thank you. Section 28, amendment 89, name the Minister. Already discussed 87. Question is the amendment be made. Is that agreed? Thank you. Section 28, amendment 90 in the name of the Minister. Already discussed with amendment 4. Question is the amendment be made. Is that agreed?
Agreed.
Section 28, amendment number 91 in the name of Deputy O'Brien, O'Leary, O'Brien, Buckley. Already discussed with 87. Is that amendment being pressed?
Yes.
Okay. So the question is that amendment 91 be made. Those in favour say Thaw. Those against say Neil. Neil. The question is lost. So the question is that section 28 as amended stand part of the bill. Is that agreed? Thank you. Section 29, amendment 92 in the name of Deputy Collins has been ruled out of order. Potential charge on the revenue. Section 29, amendment 93 in the name of Deputy Collins has been ruled out of order, not relevant to the provisions of the bill.
Sorry, Chairperson, just the fact that they're ruled out of order, can we debate them again at report stage? And could I just get clarity from the Minister, at what stage can we debate the boundary changes for the local authorities?
No, you can debate the section. Yeah.
Debate the section, but that amendment has been ruled out of order.
So I can debate the section now?
Yeah.
Yep.
After we go through the amendments, when the Chair says, do you agree to section 30? That's your...
But just for clarity, boundary changes are part of this bill, so it wouldn't be appropriate to discuss boundary changes.
We're discussing anything that's relevant to the bill.
Yeah.
Yeah.
Oh, yeah.
So unless you're inserting the section,
Yeah.
Okay.
So just for clarity, can we discuss boundary changes? Or is this the wrong place to have?
It's the wrong place. It's not part of the bill.
But when is the opportunity for us and the Dáil to do that?
PMB
That's what I
time.
want to know.
PMB time or government legislation.
So there's going to be no bill before the Dáil. This is a fait accompli. Basically, it's a decision made, and no one, regardless of what constituency, doesn't. It's in Cork South Western or a situation with Court McSherry and Timothy and all those areas that I've brought before you. The boundary changes have been made without the will of the people. So I just want to know where is the opportunity.
I understand,
to discuss that.
and what I'm going to say in response is, I come from a little place of 2,000 people in the Wexford-Kilkenny border called Tullogher-Rossberkin, and the Commission decided to separate Rossberkin from Tullogher, and now how it came about, I don't know. It's never happened before, and I'm getting my own neighbours are onto me continuously. Now, of course, you're right. I'd be the one who'd be signing the statutory instruments, and I could decide that I'm going to not sign them. But equally, we have local elections coming up, and people are deciding to run and making decisions on it. And I just think it's completely inappropriate for me as a minister if I didn't implement it. Now, it can be raised. I misunderstood what you were saying first in the Dáil and in private members' time. And I would suggest, because it is a big issue in your part of the world, that might be the way to
It's not relevant to this bill, so we're going to move on
well,
to the next section, okay?
Yeah, I just want to, just one thing is, you know, it is a huge issue. I don't think it's a very democratic process. And I know you have the final decision. You don't have to take the findings from the independent commission. The people of my area in West Cork, and I presume many more constituencies, and it's just not my own area, they want
Collins,
to know.
sorry, with respect, I'm not getting in. No, sorry,
sorry.
I know you haven't, right? But with respect, I'm not getting into a conversation around boundaries and boundary commission. This is not the relevant legislation, and I know the minister will have no problem talking to you about it afterwards. But in the interest of this bill, we need to progress on to the next. It would be unfair for me to allow you in because it opens it up to anybody else to bring in anything else, and I always try to be as fair as possible. So we're going to move on to the next amendment, which is yours.
Just let me finish, if you don't mind, Chairperson. I'll finish that.
Once it's about this bill and not about boundaries.
Yeah, no, I think it's important for me to finalise because we live in a democracy and everybody should have a little bit of a say in it.
Chair, with the greatest respect,
I have
by the rules. It's not.
this is not how this committee operates.
We know that, and you've said that, Deputy.
We've an independent boundary commission.
The only reason I brought that up was to make sure that I find, if it wasn't relevant, then I'd be told where the relevant places, because it's hugely important to my constituents. I appreciate getting that opportunity, and we'll see where we go from here.
Right. Thank you, Deputy Collins. We're going to move on to Section 29, Amendment 94, in the name of Deputy Collins, and this is the new section. You wish to press, Deputy Collins?
I do. I'd like to discuss.
You want to discuss?
Look, I suppose the Blarney, the whole situation, and I try not to delay this progress in this bill because there's quite a lot of amendments in tonight, and I know I want to revisit Amendment 45, 48, 50, 51, 52, 55, 57 at report stage, but for now this is hugely important, one for the people of Blarney and Tower, and you're talking about 6,357 people. Councillor Kevin Conway is an independent councillor, and I have to take feedback from the councillors from their areas have made it very clear to me that the people of that area do not want to be brought in under the city. And we have the whole situation that in many of my amendments, and I said I made sure that I wouldn't take up too much time, that the people feel that their voice hasn't been heard here. And the people of Blarney don't certainly feel like that. I know in Ballincollig as well, there was 6,000 or something petitions against this from happening. And I'd appreciate, Minister, you might clarify to the people of Blarney, hopefully that you could clarify that they're not going to be brought in under the city area going forward.
Unfortunately, I can't clarify that. The task was given to the implementation group to delineate, to look at the maps and delineate between what areas would in the future be in the city and what areas would remain in the county. And I would say undoubtedly when the maps were produced it would cause surprise. We're all politicians and we know when boundary maps are produced usually for electoral purposes for us that often surprises can happen and some of them can be unhappy surprises, but I would say partly in relation to the response that I've given to the previous issue that there's already been a designation now of the areas that are expected to be in the City Council for the next local elections. There's also goes to the heart of the whole process of having the group look at where to draw the boundary line. I know more than anyone in the Oireachtas issues and difficulties about boundary lines. And once you move them, and you go to the very core of people's sense of identity. And I think you would agree with me that if the proposal was to move Goleen and Ballydehob and places like that into South Kerry, that it would cause ructions. I'd say South Kerry might be happy. Some people.
Parliament Kerry, the boundaries for Kerry would run above in the restaurant, halfway down in the middle table.
No, I'm talking about the county boundary.
The local boundary divisions would run up in the restaurant at the end of January around the table with a number of Fine Gael councillors from Kerry. That's what the boundaries for Kerry would run.
We're not getting into that.
And Rathmore and
Minister, are you finished?
Rathmore and Guinea, the one parish was divided up on the table. Inside the restaurant.
Deputy Healy-Rae, Deputy Healy-Rae, the Chair is speaking, and you show respect to the committee members in here.
Sorry, Chair.
Minister, are you
Referencing the county boundary between Cork and Kerry. The issue here is the boundary between the county of Cork and the city of Cork. And I accept that there are people who have reservations. But if we were to begin the process of unpicking it now, the whole boundary line then calls into question. So I'm not in a position to accept amendment number 84. And I'm sorry for upsetting Deputy Healy-Rae.
Thank you. Deputy Collins, do you want to come back on anything there?
No, I'm going to withdraw it on the basis I can revisit it again.
Okay.
Revisit it again at
yes,
report
so
stage.
section 29, amendment 94, Deputy Collins, you're withdrawing that amendment and you'll be raising that at report stage.
Yes, indeed.
So section 29, amendment 95, in the name of the Minister, already discussed with amendment 4. The question is that amendment be made. Is that agreed? Thank you. Section 29, amendment 96, in the name of the Minister, already discussed with 4. The question is that amendment be made. Is that agreed? So the question is section 29 as amended stand part of the bill. Is that agreed? Thank you. Section 30, amendment 97, in the name of the Minister, already discussed with amendment 4. Question is that amendment be made. Is that agreed? Section 30, amendment 98, in the name of the Minister, already discussed with 4. Question is that amendment be made. Is that agreed? Section 30, amendment 99, in the name of the Minister, already discussed with 4. Question is that amendment be made. Is that agreed? So the question is that section 30 as amended stand part of the bill. Is that agreed? Thank you. Section 31, amendment 100, in the name of the Minister, new section already discussed with 77. Question is that the new section be there inserted. Is that agreed? Thank you. Section 31, amendment 101, in the name of the Minister, already discussed with 4. Question is that that amendment be made. Is that agreed? Thank you. So that's the question is that section 31 as amended stand part of the bill. Is that agreed? Members, we proposed at around 8 o'clock that we would break for 10 minutes just to allow everybody to just have a break for 10 minutes because the Secretariat can't leave. While members can come and go, the Secretariat, the officials and the Minister can't leave. So we might just suspend for 10 minutes and we will reconvene at 8:20. Is that agreed? Agreed. Thank you. Then we're into section 32.
I won't speak on that section.
Okay, section 32 is what we're coming back to.
Okay.
We're now suspended, okay? Consideration of the bill in public session. So we're now in public session and we are on section 32, amendment 102, in the name of Deputy O'Brien, O'Leary, O'Brien and Buckley, which is a new section. You wish to press? You want to withdraw? Okay, so amendment 102 is withdrawn. So section 32, amendment 103, in the name of Deputy O'Brien, O'Leary, O'Brien and Buckley, is a new section already discussed with 77. The question is that the new section be there inserted. Do you wish to press?
Likewise, a withdrawal.
Withdraw.
View to the
Thank you. So section 32, amendment 104, in the name of the Minister, which is a new section. 104 to 110 inclusive are related and will be discussed together. Minister, you wish to move?
Yes, I move amendments 104 to 110. These amendments propose to insert after the published section 31 of the bill a new part 5, plebiscites and direct election of mayors, consisting of 7 sections. At its meeting on the 27th of September 2018, the Government agreed in principle to the holding of plebiscites on directly elected mayors with executive functions for Cork City Council, Limerick City and County Council, Waterford City and County Council, and Galway City Council and Galway County Council, in anticipation of the merger of those 2 local authorities in 2021. At the same time as the local government elections in May of next year. This agreement was subject to the inclusion of the necessary legislative provisions within this bill, the Local Government Bill 2018, and the future submission of more detailed proposals on the plebiscites and the questions to be put to the electorate, as well as the specific powers to be given to the mayors. Provisions proposed for inclusion in the bill by this amendment facilitates the holding of the plebiscites. The proposed new section 32(1), inserted by Amendment 104, contains definitions applicable to the new Part 5 of directly elected mayor, local authority, plebiscite and proposal. The directly elected mayor means the Cathaoirleach of a local authority elected by the electors of the authority's administrative area on whom is conferred some or all of the functions currently performable by the chief executive of such other functions as are provided for by legislation. Local authority in this part means Cork City Council, Limerick City and County Council, Waterford City and County Council, or Galway City Council and Galway County Council together. Plebiscite means plebiscite of the electors of an administrative area that is required to be held under this part, and proposal means a proposal to provide by law for a directly elected mayor of the administrative area of the local authority. The new section 32(2) provides that the administrative areas for the purposes of this part are those of the 5 local authorities referred to. The new section 33, inserted by Amendment 105, provides that the proposal is to be submitted to a plebiscite of the electors of the area to which the proposal relates. Subsection 1 states that each plebiscite is to be held on the day and at the times appointed by the Minister by order. Subsection 2, and conducted in accordance with regulations made by the Minister under the new Section 34 of subsection 3 of Section 34. At least 30 days before the day appointed by for the plebiscite, the relevant local authorities to cause information relating to the proposal to be circulated so as to bring to the attention of the electors. That's subsection 4. That information is to contain a summary of the functions and office of directly elected mayors for local authorities, the local authorities concerned, and the likely impact on the relevant local authorities' performance of their functions, and the relationships between the offices of directly elected mayor and those local authorities and with other relevant statutory bodies, the estimated cost and resource implications, the possible advantages and disadvantages associated with the proposal, any impact for the functions of any other statutory body, and any other information the Minister considers appropriate. That's subsection 5. Subsection 6 requires the Minister to issue guidelines to the local authorities in relation to the information to be circulated under subsection 5. The new section 34, inserted by Amendment 106, empowers the Minister to make regulations for the purpose of this part, subsection 1. In subsection 2, a number of matters for inclusion in the regulations, including the form and wording of the ballot paper, the arrangements and requirements relating to publication of notices and the provision of information to electors, the appointment duties and staff of the returning officer, the taking of the poll, voting and counting of votes, the maintenance of the secrecy of the ballot, procedures to be followed in the case of misconduct, disorder, obstruction or interference, modification of electoral offence provisions applied by the new section 35, and other appropriate matters. The regulations will require to be approved by resolution of the Oireachtas at subsection 3. The new section 35, inserted by Amendment 105, applies to the plebiscite's relevant electoral offence articles that are contained in the local elections regulations of 1995, subject to any necessary modifications that are specified in the regulations made under the new section 34. The new section 36, inserted by Amendment 108, specifies the persons entitled to vote in the plebiscites as those entitled to vote at local elections for Cork City Council, including those in the area being transferred under this bill from the county to the city, Galway City Council, Galway County Council, Limerick City and County Council, and Waterford City and County Council. Under the new section 37, inserted by Amendment 109, within 2 years of the holding of the plebiscite, the Minister must submit a report to the Oireachtas specifying either legislative proposals to establish the office of directly elected mayor for any of the local authority areas concerned, and or his or her reasons for not submitting such proposals. Finally, the new section 38, inserted by Amendment 110, provides that the costs incurred in holding a plebiscite are to be borne by the local authority.
Thank you, Minister. Fergus.
Thank you, Chairperson. I just want to refer to the white paper we got today, and so that means that this is an entirely new section of the bill, and we haven't had an opportunity to discuss it or to see it, in fact, until this evening. So I just want to talk about issues that arise from it, and maybe to expand upon views which the people who vote for me feel strongly. I think, first of all, I welcome the principle, Chairperson, what the Minister is bringing in there. He's having directly elected mayors of certain local authorities or combinations of them. And I'm just going to talk about my own area, which is County Louth. And I think if you look at the population growth in the last census, and I've looked at the figures, outside of the areas there, and Dublin isn't included in there, but if you go Dublin, Cork, Limerick, Waterford, the next town in size in the country is Drogheda, where I live, followed by Swords, Dundalk, Bray, Navan, Kilkenny. So there are new changes in local government, and I recognise, Minister, that you're recognising, and indeed so far tonight you have the support of members from Cork and other places to what you're actually doing. But I think what you need to do, and I accept and acknowledge that it won't be possible in this bill to get the outcome necessarily that I would want, but I think if you can start the process by master planning for areas like Drogheda, where there has been hugely significant growth over the last number of years. Now, people may argue about the size of different towns, but if you compare the census population of Waterford City, it's 2016 is 53,504, and Drogheda is about 42,000 citizens, so it's very close behind it. And the other point that arises is that people want to be in control of their own destiny locally. Now, whatever decisions are made in places like Cork, and I have no issue with that, the people in South Louth, where I live, want to control their future. And because you have two major towns, Drogheda and Dundalk, you have the 6th largest town in the country, which is Drogheda, and you have Dundalk, which is the 8th largest. They're huge urban areas. And their population, is greater. If you look at the counties, and I've done this, I've looked at the counties of, I think it's Leitrim and Longford. The population of either of those towns exceeds and is greater than those county populations as they presently stand. Now, I'm not arguing that you make any changes in those counties. They have their county managers or their chief executives. They have all the infrastructure that goes with that. But Drogheda, which is bigger than all of those places, doesn't have it. And won't have it under this legislation. So if I could ask the Minister to respond, and in the second number of amendments that you have, I'll expand on the issue there, and it is separate, and I acknowledge that, is that you would look at taking Drogheda as the 6th largest town in Ireland, that you would look at a master plan through the Urban Renewal Generation Fund or whatever other mechanism we can find to fund and control and plan for proper and accountable local government locally in that area. And I would say that's the problem that arises then is the area contiguous to Drogheda, which is in County Meath. And now there are different views on this, but the general population of East Meath, Drogheda, and then the greater Drogheda area, people will argue is in excess of 80,000 people. And yet you don't have a definitive one-stop shop for administration there. And that's why I said the second amendments that you have will probably cover some of that. So what I'm asking you, Minister, would you consider, and could you come back at report stage, if that's appropriate, or at any other time, to look at what I'm bringing up, which is the master planning for areas like Drogheda, which need to be in control of their destiny. They have the population, they have the urban pressure, they have all of the infrastructural deficits that need to be addressed, and indeed which weren't addressed in the latest round of funding from your department. But I'm not blaming you for that. I'll take that up with the officials later. So what I'm saying is, would you consider that as a constructive way of engaging with a significant need? And the last point I'd make, and I think it's important, is that the spread of the GDA, or the spread of Dublin, is shown by all of those big towns. They're all on the East Coast. They're all adjacent, almost on the East Coast. They're all adjacent to Dublin City, and they all have significant pressures that are not being dealt with the existing, certainly the existing local government infrastructure does not meet and isn't accountable to the needs of the population there. Thank you, Chairperson.
Fergus. Owen.
Thanks, Chair. Look, first of all, yesterday when we were debating a motion in the Dáil to allow these amendments through, one of the concerns a number of us raised was that we only got the amendments the evening before. And while the Minister had signalled his intention to bring them forward, it still gives us very, very little time to properly scrutinise them and get our heads around them. I do want to acknowledge that the Minister and his officials made time for us today to kind of go through some of that. But given that we were only able to ask for that last night and schedule it today, we didn't have an awful lot of time. That's no criticism of the folks on the other side of the room. But it begs the question, which is, and I'm going to repeat some of these points when we deal with the next set of amendments because they're even more substantial. We're proposing some very, very substantial changes to local government here, and we're doing it by way of amendments with a limited amount of scrutiny at almost 9 o'clock in the middle of a whole bunch of other things. And that just strikes me, and I'm on the same side as the Minister on this in the sense that I'm a supporter of directly elected mayors, and if the powers and the relationships between that office and the other structures of local government are correct, I think it's something I would encourage people to vote for. But you're making it very, very difficult for us. And the reason I say that is I was part of the mayoral forum in Dublin when Phil Hogan was proposing the idea of the possibility of a plebiscite in Dublin for a directly elected mayor. And councillors from the 4 Dublin local authorities were asked to debate all of this and then have votes in our respective councils, and if all 4 councils voted in favour of the plebiscite, we'd have one. The difficulty was we were having that discussion in a complete vacuum. We had no idea what the powers were going to be. We had no idea whether powers would be sucked upwards from the local authorities into the office of directly elected mayor, whether powers would be devolved down from government agencies, government departments, etc. And while 3 of our local authorities, and ours was one in South Dublin, voted in favour of the plebiscite, despite the fact that we didn't know, the big problem in Fingal was, in the absence of any certainty, they weren't willing to allow the thing to go forward. Now, I know you're going to tell us, as you did earlier, that next year we'll deal with the more substantive issues of powers and relationships, etc. But that legislation isn't going to be passed before these plebiscites. So the government might be able to say what it would like to do if the plebiscite passes and if it gets the legislation through. That's a lot of ifs and buts, and that's a sure way to lose a plebiscite, or certainly a way to confuse the public and make it difficult for them to really engage with it. So I suppose I'm on your side on the principle of this, but I do want to express genuine concern at the sequencing of it. And given the fact that you're telling us that if this goes through, if the plebiscites pass, and if the people in the respective areas support the proposition, it could be up to 2 years before you publish your report to set out the legislation to. Does that mean the timeline here really is directly elected mayors subject to the passing of a plebiscite for the local government elections, not next year, but the ones that come after that? And if that's the case, then why are we rushing what essentially is a separate piece of legislation in amendments into this one? I also have some small concerns, and I'm going to raise them. I may or may not table amendments on these specific things come report stage, but I'd much prefer it if you look at them again, because obviously if you bring forward amendments of your own, they're more likely to pass. Without opening up the Galway debate, because we're going to have that afterwards, it is kind of presumptuous the way Galway is inserted in this, right? So, okay, I understand you'll have a plebiscite in the 2 different parts of Galway as they're currently constituted. But what happens, for example, if the good people of Galway City and County, in their wisdom at a later stage, decide to follow the Cork model and instead of having a merger, have a boundary extension? I'm not saying you would propose that, but let's say that were to happen, right? Then the plebiscite that we're going to hold in May of next year won't be valid for what could be the new enlarged Galway County Council. And again, that's a matter for folks in Galway to go through in detail. It's none of my business. I don't represent the area. But it is a problem, and a significant problem, in Section 32. Section 33, and I did raise this at the briefing earlier on, is the information to be provided. Now, we know the difficulty we have in referenda, right? We have an independent referendum commission set up because of the difficulties in terms of government bodies issuing information in referenda. And it's all very well to say the local authority, following instructions, regulations from the Minister, will provide factual information. But let's wait to see when we have the plebiscites if facts become opinions and opinions become, differences. And again, I'm concerned that those regulations might not require a sufficient level of independence in the presentation of the information that we're now accustomed to in the referendum. That could just be a genuine difficulty. Section 37, I just don't understand the timeline. Why 2 years? Why not 6 months after the passing of the plebiscite? mean, if people vote in favour, if, the good people, for example, of Cork or Limerick say, no, we want this, why wait 2 years? Why not, within a relatively speedy period of time, bring forward at least your outline proposals? And then I do have a concern in Section 38, the new Section 38, on costs, right? We're being asked to impose the costs of these referenda or plebiscites on the local authorities. We don't know what they are. Now, again, I did raise this and the officials said that they had some indicative costings, and if they could share them with the committee, that would be great. But, for example, a hard-strapped local authority that's already passed its estimates now, when it comes looking at this plebiscite next year, they might have to take a decision to limit the distribution of material to fit the cost available to them. And that would obviously be potentially impacting on the overall turnout. Whereas if they were to decide, no, we're going to send literature into every house in the city or county, we're going to put new ads in the newspapers, those costs start to become significant. And for some of the smaller local authorities, €20,000 can become 50,000, can become 100,000. And while I appreciate these plebiscites will be carried out on the days of the local and European elections, so the count and those things will already be covered, even just the dissemination of information, that could be a significant cost. And does that mean, for example, if we allow Section 38 of this amendment to go through, then Galway City or Limerick City and County have to then go back and revise their estimates, even to find 20, 50, 80, 100,000 euros, depending on the cost? If you can reassure us in terms of some of your estimations of the cost, I'd be thankful on that. I'm also not clear why Dublin isn't included. And I'm not arguing for an amendment to include Dublin, because I think there are a set of complexities in Dublin, but there are many parties, including my own, that if the configuration is correct, we'd support such a thing. Our party isn't going to oppose this amendment, although I will, subject to the answers, at least have recorded my opposition to the proposed new Section 38. I just want to express a concern that, for somebody who'd like to be enthusiastically supporting this, you're making it really difficult for us. And if you're making it difficult for us, if and when it gets out to the plebiscite and the debate in the public arena, I think it's going to be even more difficult for a lot of the electorate.
I'm not going to repeat much of what Owen said. Was matters that I was going to raise, and I do have a concern about the timing, something as fundamental as this being included at a late stage in the bill. And I do again recognise that you briefed members and your officials briefed members early today. I do remember a previous Minister for the Environment in relation to the directly elected mayor in Dublin, and my county was the only one of the four who actually opposed it. And the reason the councillors did, in their wisdom, and I agreed with them actually, was because there were no detail. There was no detail of how these mayors, the mayor, directly elected mayor, would operate, how the functions of that mayor would actually integrate with the existing structures within the local authority. So that question would still be there for me right now. I think I can answer the question as to why it is now, is because we have a local election and a European election in May next year, and I think the department and maybe Minister, you could clarify that, have obviously taken a view, or government indeed have taken a view, that it would be expeditious and cost effective to have these plebiscites on the same day. So the cost element, I think I would like that clarified firstly in Amendment 38. I'm just going to deal with the grouping here. Again, I would like the logic, to understand the logic of the four areas that you've actually selected. One could ask your native city, which Kilkenny is a city, and people in Kilkenny are always at pains to tell us so, as to why the other city in this country actually isn't included. Deputy O'Dowd makes some points. Swords, we could mention towns that are bigger than cities like that as to why one would do it. But what I want to get a handle on is the time frame. You're saying in advance of the. In 33, Amendment 33, you're talking about the information for the purposes of the plebiscite. The local authority concerned shall not later than 30 days before the day appointed, under subsection 2, cause information relating to the proposal to be published. Like, how advanced is the work within the department about the functions of these directly elected mayors, what functions from the chief executive they're going to take, the term of that directly elected mayor, as well, like fundamental things about how this directly elected mayor would actually operate. And if in Amendment 33 the department are saying that effectively we will have that, 30 days before the plebiscite. I think we need to do a lot better, and I know you're setting that as the minimum, but when people are unsure about things, they generally vote against them. And I as an individual who supports directly elected mayors, and my party, Fianna Fáil, do also, I think that we want to make sure that we're going to get this right and that it's not rushed and that it appears rushed. I do want to ask in relation to 37, and this is the timing, it goes to the 2 years, and maybe this is just a drafting piece, but it says, the Minister shall, in respect of each administrative area, in respect of which a plebiscite is held in accordance with the part, and not later than 2 years, okay, lay a report. But you're saying areas which a plebiscite is held. I'm taking it that's a plebiscite that is passed. Okay, no, you're going to report back anyway whether the people. So you're saying that a report specifying proposals for the enactment of a law providing for a directly elected mayor. So for argument's sake, if it was a question that one of those 4 cities, that if it was Limerick decided by plebiscite we don't want it, you would still, or the Minister, you were not going to bring that forward?
No, the report doesn't have to be positive or negative. It'll be a report. On actions following on. But it goes a little bit further than that. Sorry, it says a report specifying proposals for the enactment of a law providing for a directly elected mayor for such administrative area. So actually, it doesn't say that. It actually it's the next section. Look at the next section.
Well, a report specifying the reasons for his or her not preparing or submitting a report. That again, I would put it to you, and I think you need to look at that for report stage. It's slightly different. That actually, my reading of it would also give you a reason, even if a plebiscite was passed, not to prepare a report and submit within that 2 years. That's how it reads also. So I actually think that in that one could actually read that in another way.
No.
Well, I would say that I would ask you to look at that, and maybe to come back at report stage, because it says a report specifying the reasons for his or her not preparing and submitting a report. It doesn't say not preparing and submitting, a law providing for directly elected mayor. It doesn't state that. So I just think that that's something that needs to be clarified. But look, in the main, we're supportive of the proposal. We want to make sure that people have the information in good time to make an educated judgment about this, and I think the functions are the fundamental piece behind this, and we're deciding on it, we don't see it. So I'd like to finally say is, when do you hope, and do you have a time frame around that you would be able to bring those proposals back to committee to say here's what we're looking at by way of the functions for the directly elected mayor, and do you intend to do so, or do you intend to leave it to your department to just simply publish them within 30 days of those plebiscites being held? Thank you.
Here, look, I'm going to be very brief. I'm opposing to I oppose this bill. I don't agree with it. I think it's wrong, Minister, and I've said it from day one, that Galway should be lumped in with this. If a merger is to go ahead, and I'll touch on the plebiscite in a minute, it should be a separate bill on its own merit going through the Dáil, not put in with Cork. I don't agree with what you're proposing to do with the plebiscites regarding the director elected mayors. I think, and I firmly believe, the system that we have in Galway. I've always supported it. I think it works very well. In your opening comments on this section, you said that there would be a plebiscite, a directly elected mayor in Galway City and a directly elected mayor also in Galway County. Are you going to have a plebiscite on both, is it? To see what happens if it's rejected by the people. What is the outcome then of that, or what's going to happen?
Well, the report will issue, and the report will say no action if it's rejected. Yeah.
Or will the Minister come back and say, well, I'm going to enforce it and go against the will of the people?
It would be a foolish Minister that would come back and go against what the people have voted for or against.
I'd like to know, why is Galway put in, and why you're trying to widen the scope of the bill to include Galway, to cover where you'd only Galway in 2 lines in the original bill, and now we're trying to be expanding on it. But look at, Minister, I don't agree with this proposal, and I will be opposing it.
Thanks, Noel. Eamon?
I'm a member of the Dáil Reform Committee, And today we passed a mammoth memorandum to do with pre-legislative scrutiny, money notices from government and so on. And this is for bills in the main that has about 3 sections in them. But without any pre-legislative scrutiny, you've really written a new bill in an old bill. You've doubled it. That is, I couldn't believe it today when I went into the computers this morning to look at the amendments that were going up this evening, to find that there were 41 pages, and I think there are 37 lines in every page of a text, of amendments to the bill. And when I pick up the bill itself, I find that all we have is 30 pages, not even 30 pages, because on the back is just the long title. So there are actually more pages, way more pages, of amendments than there are of bill. Now, I'm long around the house here to know the form. You come back after the summer break, or you come back after the Easter break, and the House is looking for something to debate for weeks and weeks, and those of us who are long here know that nothing ever changes. We can have all the reform we want. Those weeks, and we're discussing reports and we're looking for something to do, and particularly coming up to the Christmas, suddenly we have to do a year's work in 2 or 3 weeks. Now this one really adds insult to injury, because not only are we doing a bill, but we're doing a bill within a bill. It's Shakespearean. It's like a play within a play. And we get these after the second stage, and we get them with huge, huge implications. Now, I once foolishly, as a minister, added something to a bill. It wasn't a massive issue to a bill. After the bill had gone through the Shannon when it was in the Dáil. And it was probably the decision, even though it looked very innocuous at the time, that caused me the most grief as minister subsequently. And I learned one session, don't trick around with the House and don't trick around with the people. That the longer you spend in here, going through it in a constructive and interactive manner, accepting changes, making amendments, the less grief you'll face in the future, and never dismiss amendments, no matter who suggests them, as long as they have validity. Well, what we're getting at the moment is a different approach. The approach that we've decided we'll push through. Now, I have to say that I'm astounded to find that Galway is included in the plebiscites here. And we'll come to the more substantive issue when we get to the opposition by my party and by a number of my colleagues here to the section in relation to the Joint Chief Executive. And it seems to me that despite the fact that the vast majority of public representatives in Galway believe that they should adhere and that the government should adhere to Eoin O'Sullivan's report, which says money first, all other issues after that, that the government insists on trying to put the cart before the horse. And this is a very, very, very serious situation. And I'll make the prediction here that this rushed Christmas legislation, which is a norm and has been there, and is seen as a device because people are busy with visitors in the house. There's many, many things going on all around the place. You'd want to have bilocation around here this evening. That people will take their eye off the ball, will get tired, and that it'll get passed, and you probably will pass it. But I guarantee you, if you think that that's what's going to be the end of this, that that'll be the beginning of the grief that you will suffer. So, Minister, I think you're making a big mistake in your approach. I think that if you wanted to bring in a second local government bill it would have been much better bringing in a local government bill 2019 that would have incorporated all these in a separate bill, rather than trying to, at the last minute, without any wide discussion in the public, without any wide discussion or consultation. I think you would have been way, way wiser to hold off, do the interactive thing that we all promised at the beginning of this time. That is, that it will be open and transparent and interactive, inclusive, that there will be new politics, that there will be no more ramming of stuff through, and that we'd really bring democracy back to Ireland. And I have to say other elements of this smack of actually not trusting elected people, and that there is a consistent theme over time to try reduce the power of elected people over what's happening. Now, I've also learned to be very wary of bulky documentation, bulky amendments where there's words and words and words. And I had the perfect example of it yesterday. At a meeting with the National Transport Authority.
Sorry, Deputy.
Sorry, it's very relevant to this.
Well, yeah, I know it is, but we're actually here since 6 o'clock. We haven't put any rush on this bill in any shape or form. We haven't put any time limit on it. And with all due respect, all members have just kept to the bill here tonight.
And I want to explain,
so I'd ask you
I think you'll understand what I'm saying, why I want to encourage that before we rush in.
It would be great if you were direct.
Yeah, I will be very direct, Chair. And I'll just finish on this point to just show you how dangerous not taking the issue when it comes up in a form like this, early on, where obviously it's hard to engage the public in all these dry words, but the massive consequences it has, and I'll go and finish my point. I had a meeting with the National Transport Authority yesterday, and I was looking for an explanation as to why the cost per kilometre of fares out to, say, Clare Galway, or twice that of Oramore, or out to Carrow, or twice per kilometre that of Galway City. And what the Chief Executive of the National Transport Authority told me was that the fundamental reason for that was the National Planning Framework, because it would encourage people to live outside of the cities if they had fair fares on the bus services. And that when we passed the National Spatial Strategy, we mightn't have realised that the effect of this was going to lock us in to a double fare basis just for those who live outside the magic circle. So I am absolutely convinced that if we pass this as it is, if we go for the plebiscites in Galway, that basically we're being brought to a place where there's a hidden agenda, hidden away because you're afraid to up front and tell the people. But over time, like in the case of the fares on the buses, you suddenly find that there were a lot of agendas there that were not told to the people at the time, because it would be known that if the people knew, the people would reject. I'm finished.
Michael?
Me. Thanks. Thanks very much.
Yeah.
First of all, Minister, in the line of this bill, I think it's agreed right around by everybody that there's a massive shortfall of money in Galway. I don't think, from even, in fairness to the department, it's fully agreed that that's the situation. If you read the report in the line of the Galway situation, it states that we need funding. It's the first thing that's put in it. And I know that there has been some moves afoot, and in fairness, you've had 2 meetings with us, and we thank you for that. But at the end of the day, Galway is, it's not just 500,000 or 1 million. There is a lot of millions, as has been pointed out to you. There is major concern in the rural areas in Galway that obviously the municipal districts are under pressure. there is areas right around this country, not alone Galway, where unfortunately population may not be what it was. And going into the future, when you look at some villages, you will see some villages with rural decline. And we've got to face that fact. But the representation in those areas is very important. In the line of monies that's required, we need to make sure that it's ring-fenced for those areas to try and keep them vibrant, because in fairness to all politicians, they are trying to ignite small villages and rural areas right around the country, not alone in Galway. And I think that at the moment we are sort of putting the cart before the horse, really, that we need to find if Cork is going through and the opposition are supporting it. I don't know much about Cork. We'll be voting on something in Cork that, to be honest about it, we'll know damn all about. I think the people from Cork know more than any of us in that. But in the line of the Galway one, I think we need to think this out well. It needs to be done right. But the first step up the stairs in this is that the money is put in place to put on a level playing field. It's nearly agreed by all as well that the system used is flawed, and we need to right that system and make sure, not alone for Galway, but for every other county that hasn't got their fair share. And Galway borders a lot of counties, and there's a lot of peripheral areas that every TD and every councillor is working hard to try and pull a few quid to those areas. And by its nature, Galway City is going to move out. It's gone out to Berna, it's nearly out to it. There doesn't seem to be, in my opinion, a plan for Galway. I would have a Lewis or something in it. I know that the outer bypass has been done, but then you need a transport infrastructure. I can come to Dublin as quick as I can go to Galway, and it's only 40 miles, and that's not good for people going in the morning. But the peripheral areas are really, really worried and concerned that going down the future, there'll be sort of the forgotten people, and that as you move out towards Berna, and whether we like it or not, it's going to go towards Orden-Moormarie, and that's areas, you know, that's facts. That's areas getting more prosperity, which is good, and no one disagrees with that. But then you move more that you'd have nearly extra city councillors, because obviously they'll be making sure of their own areas. And I'd like to know your thoughts. Like, I don't know much about mayors in different places, but I'd like to. My understanding in Limerick is that there was a lot of problems, and I've heard people talking about Tipperary. I'd like to hear your thoughts on that. But I think that if we were doing things right, if Cork is in agreement, we're from Galway. We don't know enough about Cork. It's like someone from Cork talking about Galway. They wouldn't know the ins and outs of it. And that's no disrespect to them. But I think that if we could, Galway, in my opinion, deserves something on its own. We are willing to work with you. There's no such thing as we are willing to engage. But the report that was done, the first lines of it says enough. It's basically show me the money, and that's all I have to say. Thank you.
Thank you, Michael. Catherine?
Thank you, Chair. I want to come in at the later section, but I just think I've been very outspoken in the Dáil on this. I think it's wrong. I don't think Galway should be included at all in this bill. It's a very simple matter. It has been stuck in. It leads to lack of trust as to why it was stuck in, and now we're looking at plebiscites. While I'm not against a plebiscite in general, the manner in which it's been done and the extra stuff that we've been given, I won't repeat it because I've said it in the Dáil, and I want to speak later on the amendment, but I do think it's a nutter cynical exercise to deflect us from the real problems on the ground in Galway, which I'll come back to when I'm speaking to the amendment.
Minister.
Okay, I will try.
Sorry, Anne. Sorry.
Yes.
2 seconds, if you don't mind.
You can indeed, no problem.
To be quite honest with you, Minister, right on the ground in Galway, funding, as Deputy Fitzmaurice has said, and every one of us will tell you, is our key issue. It's the biggest issue. The budget was not passed last Monday. It was supposed to have been done last Monday. And the reason the budget wasn't done last Monday is
they actually don't know how to pass the budget. They don't have the funds to pass the budget. And it's not the first year that they've found themselves in this position. This is their third year that they've found them in this position. None of us are against a plebiscite or anything else like that. But at this stage in Galway, the lack of trust amongst all the sitting councillors is unbelievable. And the further you leave the city and go out into the rural communities, the more you feel aghast at the disparity between the city and the county. And there's a real lack of trust at this moment in time. And the fact that this is after finding its way in with Cork, the trust or the distrust has become more and more. It was in what it said. I attended all those meetings around the merger and everything else. I know this is not what the conversation is, but it did say at the very outset of the report, funding was required. So basically what I'm here to see is show us with the money, because it comes at a price. And I think that's what the councillors are looking for. And that's what I'm representing as their voice. That's all I have to say.
Thanks, Anne. Eugene?
Yeah, thanks, Chair. Very good to say on the basis that I suppose I represent part of the constituency, but not a big part, but it's an important part. But look, I back the other speakers who have spoken, Deputy Fitzmaurice, Deputy Conley and Deputy Rabbit. There is a huge issue with the finances, and offering a small amount of money to the various areas, the municipal districts, is not a carrot that does much good, because the deficit is so huge. And you're talking about a population now between city and county of almost, I think it could be up in 320,000 people. It's certainly in excess of 300,000 people. That's a huge population. So we need to get real about Galway city and county. I think it's about 275 in the rural, and then the city is over. Well, I have the figures.
250. 250.
250. So it is quite substantial. Why are you shaking your head, Minister?
It's
population
of the whole lot. You were going over 300 there. That's all.
Well, it's between 70 and 80,000 for the city. I only checked my figures yesterday. So it'd be no harm to have a check on those figures, because it's quite substantial. But anyhow, well, there's 250,300,000. It's a huge amount of people, and we need some real planning, and we need some, real money. And as other people have said, the local authority, through the chair, they don't have any faith at all at the moment in the whole system. They really don't. And we're going to have to, number one, sort out the money issue. And I mean, some of the outlying areas, I represent the Ballinasloe area, and they feel completely left out for years, to be honest. So that's my contribution, Chair, and thanks for letting me in.
Thank you, Eugene. Minister?
City, there you go. 79,000 in the city.
Yeah, and about 170 in the county.
I rest my case. No, it's more than that.
Minister?
I wasn't trying to be picky, but the numbers weren't adding up. But numbers often don't add up, and maybe that's at the heart of this this discussion. In relation, we started with Deputy O'Dowd. Amendments were circulated on Monday night. I understand that, and several deputies have spoken about the fact that more time would have been desirable, but it was firmly indicated at second stage that there would be amendments in relation to plebiscite and in relation to the urban area committees. And certainly in relation to the plebiscite chunk of amendments, the group, these amendments are solely concerning the actual structure of how a plebiscite would run and the subsequent actions that the Minister of the day might take. There is no facility, even it would be inappropriate within this legislation to spell out what powers that the directly elected mayor might have. And I want to, I suppose at this point, make reference to the fact that in early 2019, quite probably I would think at this stage in February of 2019, the intention is that the government will consider a memo. And the memo hasn't been drafted. I think it was Deputy O'Brien who asked the question. And what I suggested at the briefing earlier, and I'm suggesting now again, that we should have either a meeting of the Joint Committee or a meeting, a statement in the Dáil and another one in the Shannon. I'm perfectly prepared to do it for as many hours, because I actually think on the issue of direct election, there isn't as much that divides parties as there might be on other issues. And I think it would be good to have it well in advance of when the memo goes in, so we can feed into the part of the memo. Subsequent to the memo being adopted, then that would form the basis of which information will be made available to the public in advance of the plebiscites taking place. And that should be done. I would emphasise again to members who've asked questions about timelines. What it says here is that it must be done by 30 days. That doesn't mean that it will be on the 31st day out from, but that's just to give a statutory minimum. And equally on the issue of reporting within 2 years. Certainly it wouldn't be my intention at all. If the plebiscites are held, certainly if there's a rejection, the report should be short and sweet and should be very quick. The report on actions to be taken if the plebiscite has a positive result would be obviously a more lengthy thing. But again, it's to put a backstop, to use that word again, that up till now, and you discussed it, Deputy O'Brien, and I think Deputy O'Brien and others, that in the context of Dublin, this discussion has been going on for years, but there's never been an end point. So at least we want an end point to the plebiscite issue, which is the 2 years, but it wouldn't be the intention that the 2 years would be a minimum at all. In fact, very much a maximum. In terms of the urban area committees that Deputy O'Dowd raised at the start, Part 6, which is 4 sections, speak to that, and it's obviously a big issue in your part of the world, with a huge chunk of Drogheda that's in County Meath, huge chunk of Waterford City that's in Kilkenny, but as I said earlier, danger here, we won't go into too much detail on that, but in relation to your issue, as I understand it, and I was only looking at the applications, the headline issues of the applications that were made by different local authorities. Some local authorities under the Urban Regeneration Fund completely opted out of making any decision themselves and put in 9 or 10 applications. And that's not the basis to secure funding for anything. Some local authorities put in very specific proposals and secured funding. The issue in the Drogheda Relief Road, to the lay observer, was that it wasn't urban regeneration. But I do believe that what you're talking about now in terms of a master plan for Drogheda or for any town, that's very much part of urban regeneration, and in February of next, that application system opens again. And I've already, and I will endeavour before report stage to speak to my colleague, Minister English, who is the man responsible for planning issues, in relation to the very reasonable suggestion that what's been designated under the MPF as areas for development, that they should get more resources to allow them to pursue that development. Yeah. In relation to Deputy O'Brien, as I said earlier, memo in January. I have no problem having the debate if the members here wish to have it at committee or wherever. But I would say, and I can't remember, it was Deputy O'Keefe spoke about pre-legislative and some meeting was that today. It's my understanding that the committee didn't seek pre-legislative scrutiny on this, and that the Galway proposal was in it when that decision was made not to do it. So I can't be accused of not being available. I'll go to meetings until and I mean on this issue there have been multiple meetings and there'll be multiple more. But it's just factually incorrect to talk about pre-legislative scrutiny. The committee made a decision not to do it, and Galway was in at that point. That's not my fault. It's not these people's fault. Not saying it's the committee's fault, because this is a particularly busy committee. In fact, if you were to, I think there's great merit in the future that local government should have its own full committee, because of the amount of stuff that comes into the committee. Further to that, I would just say that there was a report that the Cabinet adopted about 3 months ago, one of the first reports I presented to Cabinet, and it was on the issue of directly elected mayors. And it received some publicity in the paper. It was submitted to the committee for consideration. But again, the committee is busy, and it wasn't considered by the committee. That isn't my fault either. It isn't the committee's fault either, because you're grappling with housing primarily. But it's also not a fair criticism, I feel, that the discussion didn't happen. There are certain time sensitivities associated with this bill, not least the fact that people will be contesting local elections next year, and in the area of Cork, people who are considering running want certainty as to boundaries. There's also issues in relation to the establishment of electoral registers, which we mentioned at an earlier section in the bill. But I don't accept that it's, and I know the point that Liuki is making in relation to rushed. I've been here 16 years, and there's always a kind of pre-Christmas rush, but we've been looking to get on the schedule with the Business Committee for a long time. And the battle we're fighting, and I would say to all of you who have representatives on the Business Committee, we want your support to get it here quicker. But now that we are here, we should have the discussion, but it's not any effort on our part to stop it from coming to this point. In relation to Deputy Grealish, spoke of the merger. Yes, if the merger should go ahead, it should be a separate bill. It should be, and it will be a separate bill. There will be a local government bill 2019, next year, which will be primarily about Galway. But like all local government bills, there will be other sections relating to other aspects of local government. It's just one of those areas that there's pieces of legislation that often refer to different issues. But Galway will have its own bill next year, and that's very much my intention. You don't agree with directly elected mayors, and a lot of people, I would suggest, particularly in local government, probably don't agree with directly elected mayors. And I don't have any, there is no answer. People differ, and the public will decide ultimately. Galway was put into this particular piece of legislation insofar as it is in relation to the chief executives, because all of the mergers that have happened in relation to Limerick and Waterford and Tipperary all initially started with the appointment of a joint chief executive officer. What we are proposing to do, and I will go into some detail on, is address also the key points in relation to funding. As I've said from the start, and when I got this position 18 months ago, whenever it was, there was a significant historic problem in the funding of Galway County Council in particular. And it stems partly from the fact that, you know, the City Council established in 1985, and that had an impact on the funding for the county, and it was never dealt with properly then or subsequently. And I will be able to mention a bit more at a later point about that. I just want to refer to Deputy Eugene Murphy spoke about issues of I'll be coming back to other issues, spoke about finance as well, as did Deputy Fitzmaurice. He spoke about his understanding in Limerick. The understanding in Limerick, and you talk to our Oireachtas colleagues in Limerick, Limerick is a city transformed. Now, whether it is transformed by the merger of the local authorities or not, I'm an outsider.
Time for you to finish it, but just let members know there is a vote in it all, and we'll be suspending in a couple of minutes to allow members to go.
I have to go, Chair, but I do want to apologise. Actually, I was wrong on my
Yes,
cities for the rule. I apologise, you were right. So my apologies on that.
If I thought you were being malicious, I'd have taken the head off.
Don't say that.
And ended up back in the courts.
Will we suspend?
Do you want to? I'd say another 2-3 minutes to be okay.
In relation to what Deputy Fitzmaurice said, the Limerick example is what I would hope will happen in Galway. And there's a geographic issue in Galway. The Galway is a huge county, and Deputy Connolly mentioned this in the second stage. But the geographic area is not going to change very much. The population is obviously changing, but how do we ensure that we create a powerhouse on the West Coast? And I would see a united local authority as being a leading part in transforming the fortunes, particularly of County Galway, because so many of those towns that you know and villages have become dormitory towns. Their centres are gone because people are doing their shopping and their business in Galway City. So therefore, I think that's an argument in itself for having a single unified local authority. I don't believe, and Deputy Connolly's, I don't know if she's aiming at me necessarily. Bigger isn't better necessarily. But I think that when you look at a county and city of Galway where the city is doing relatively okay, possibly quite well, and the county in certain areas has suffered for a long time. Partly funding of local authority, but partly the planning and the lack of retail and business and infrastructure in those towns and villages in County Galway. I think a unified local authority will benefit those what have become dormitory towns, but we want them to become functioning towns again in the future. That's the purpose of the Galway, from my point of view. And I don't want to be seen to be bullying anything through by anyone. Deputy O'Keefe mentioned and threatened grief on me afterwards. There's no attempt to bully.
Minister, can I just ask, Deputy O'Brien just has a clarification. Have you a quick question you want to?
The Minister won't be able to answer it in the time we have before we get to the vote.
Okay.
I'll be very brief when we come back, if that's okay.
Okay, okay. Okay, members, I propose that we suppose to allow us to vote and then come straight back. We suspend, sorry. Yeah. Consideration of the bill in public session. So we are now in public session, and Eoin, you wanted to ask a couple of additional questions.
Thanks, Chair. And look, Minister, thanks for the replies. And just a couple of quick things. We're always very polite and friendly in this committee. You'll learn.
Well, the members are.
That's my point. Just let me say this on the pre-leg, and I'm only saying this because you're going to be coming back to us with other bills. If some of the amendments that we got on Monday night had been in the bill originally, we might have taken a different view of it, right? And I'm only saying that because
I only said it because
accept that.
A man gave a speech about pre-leg.
I accept that, but I just want to say this because it's relevant to the future bills. Is those of us that took the decision not to have pre-legislative scrutiny was on the basis of the bill as published, and I just want to put that on the record. Look, just two quick things. I did ask you about the new Section 38 in terms of costs, and just if there was some information on that. That's just the additional cost to the local authorities. And I did ask about Section 30, the new Section 33, and the information and how that could be handled to make sure that it is done in a fully impartial and fact-based way.
Brief answer: I don't want to guess the cost. We know that the cost is going to be very small because it's being run. You know, there's no counting costs and stuff like that, and the actual cost of holding the plebiscite. But the costs in terms of the information and indeed a methodology to ensure that the information can be in some way balanced. I would certainly consider that in advance of the report.
So the question is Section 32, Amendment 104 from the Minister, new section, that this new section be there inserted. Is that agreed?
Agreed.
Thank you. Section 32, Amendment 105 in the Minister's name, already discussed. 104, the question is the new section be inserted. Is that agreed?
Agreed.
Sorry, Eoin.
Yeah, sorry, absolutely.
Section 32, Amendment 106 in the name of the Minister, already discussed with 104. Question is the new section be there inserted.
Agreed.
Section 32, Amendment 107, name of the Minister, already discussed with 104. Question is that the new section be there inserted.
Agreed.
Section 32, Amendment 108, in the name of the Minister, already discussed with 104. Question is the new section be there inserted. Agreed. Section 32, Amendment 109, in the name of the Minister, already discussed with 104. Question is the new section be there inserted.
Agreed.
Section 32, Amendment 110, name of the Minister. Already discussed at 104. The question is that the new section be there inserted. Agreed. Section 32, Amendment 111, in the name of the Minister. The question is that the new, it's a new section. 111 to 114 inclusive are related and will be discussed together. You wish to move, Minister?
Yes, I move briefly. These relate to the urban area committees, and it's proposed in Amendment 111. It contains definitions applicable to the new Part 6 of urban area, which is to be construed under the following subsection, and greater urban area, which means an urban area and any other part of a local authority area that is designated by an urban area committee under the new Section 41. Subsection 39.2 provides that an area lying with the administrative area of more than one local authority is an urban area if it has a population of between 1,500 and 100,000 and dwellings are spaced no more than 100 metres apart, and the population applicable to each of the component local authorities amounts to at least 15% of the total, or 1,500 persons. The new Section 40, inserted by Amendment 112, requires the establishment of urban area committees within 6 months of the commencement of the section by those local authorities in which the urban area is situated. The members are to be appointed by the local authorities involved in the urban area and are to consist of the Cathaoirligh of the local authorities concerned. 3 other ordinary members of each local authority will be selected in respect of the local electoral areas where the urban area is located, and between 2 and 4 people who are not councillors with experience and expertise in areas of transport provision, housing provision, infrastructure development or business and trade, nominated by the Cathaoirligh in accordance with guidelines issued by the Minister in subsections 3, 4 and 5. In accordance with subsection 11, the members who are not councillors are non-voting and can't be the chair. The chairperson of the Urban Area Committee is to be appointed from among the members by the members unless the members fail to do so within 2 weeks of their appointment to the committee, in which case the Minister will appoint the chairperson. Urban area committees are to hold as many meetings as are necessary for their functions, and their local authorities are to set the date and place of the first meeting of the committees. Committee meetings are to be chaired by the chairperson if present, or else by a member chosen by those present. Questions are to be determined by a majority of the voting members, with the chairperson having a casting vote. And the meeting quorum is 4 voting members. Subsection 12 provides that the committees may act notwithstanding membership vacancies, and subsection 13 provides that they may regulate the procedures subject to this section. In accordance with subsection 15, administrative support to the committee is to be provided by members of staff selected by the committee from nominations made by the two local authorities in consultation with each other. Subsection 16 requires the assigned support staff to perform functions on behalf of the committee under its direction and control. Amendment 113 inserts a new section 41. It relates to the designation of the greater urban area and local area planning. Subsection 1 provides that an urban area committee may designate any part of the local authority administrative area that adjoin the urban area for the purpose of this section dealing with its functions. Subsection 2 provides that if the committee has not made such a designation within 3 months from its appointment, the Minister may make the designation by order. Subsection 3 provides that the functions of a planning authority under Chapter 2 and Part 2 of the Planning and Development Act 2000, which concerns local area planning, are to be performed by the Urban Area Committee in relation to an urban area, and subsection 4 provides similarly in relation to a greater urban area. The main function of the Urban Area Committees will be the production of the local area plan for the cross-boundary urban area and its contiguous areas as designated by the committee, including the appropriate zoning as an explicit function. In the case of these towns and cities, the current position whereby the local area plan is required to be consistent with the local authority's development plan will be reversed, and the development plan content for both local authorities will have to follow on from and be consistent with the local area plan that is made for the cross-boundary area. It will not be possible for either local authority to amend or revoke the local area plan approved by this committee. Transferring responsibility for local area planning to the urban area committees is in this way necessitated a number of provisions to adapt how the local area planning provisions of the Planning and Development Acts are to operate in relation to the urban area committees. All the paragraphs A to E in subsection 3 accordingly amend or adapt how sections 18 to 20 of the 2000 Act apply in relation to urban area committees performing local area planning functions for the urban area. And subsection 4 applies many of the subsection 3 modifications to the performance of local area planning functions for the greater urban area, and also adds a number of additional adaptations in that subsections paragraphs A to E. Subsection 5 disapplies Section 131A1 of the Local Government Act 2001, which relates to the performance of reserved functions in respect of municipal district members, and part of the associated Schedule 14A includes local planning functions from the Urban Area Committee functions prescribed in this section. The final final section of this part, the new Section 42, which is contained is an amendment to Section 10 of the 2000 Act, is inserted by Amendment 114. It amends Section 14 of the Planning and Development Act of 2000 to add a new subsection 11, providing that a provision in a development plan that is inconsistent with the local area plan made by an urban area committee under this Act shall not have effect in relation to the urban or greater urban area concerned.
Members, with your agreement, can we extend the meeting to 10:30? Right, thank you. Okay, Pat.
Thank you, Chair. Just in relation to the amendments that's been put before us here tonight, and I just want to have my first say in relation to this. I think it's disappointing that they're coming so late, and I want to put on record that we might need to make amendments to these at report stage at this stage, and I hope the Minister will accept amendments at report stage, because we haven't had, in fairness, to have a decent discussion around this whole section specifically. Just a few points of clarification. I assume the makeup of this urban committee is made up of the 2 cohorts from each administrative area, 6 councillors, and 2 to 4 members of society, based on other things. I suppose I have a slight concern here in relation to why, at this stage, do we need 4 members from society on a committee, when we trust our local councillors to adopt local area plans, we trust our councillors to adopt county plans, and we trust our councillors at assembly level to adopt regional plans. So I'm questioning why at this stage are we bringing in private people into a democratic process that has served us well in the past, and the reasoning behind that, if I could get some understanding of that. Equally, you're saying that the private sector have no voting rights, if I'm reading the bill correctly. And just in relation to the election of the chairman of that committee, do they have a say at that point? Because it just says the chair of the urban area committee shall be appointed from among the members. It doesn't say anything about voting rights in relation to that. What sort of powers are we giving this urban committee? Because I'm not too sure whether they have to follow the very same rules as the local authority does when it comes to local area plans or county development plans, or are they short-circuiting that process? Because at one point in here, I think they can, for the purpose of this section, an urban area committee may designate any part or parts adjoining the urban area concurrent of the administrative area of the local authority in which part the urban area is situated. So are you saying without any consultation, this committee has the power to expand the boundaries wherever they seem or deem fit? And maybe just clarification that when they do their own urban area plan, that they have to follow the very same procedure as a local area plan or a county development plan, or can they short-circuit that process? Just a few observations in relation to that.
Owen?
Chair, thanks very much, Minister. Thanks for the explanation. I think of all of the amendments that were covered by yesterday's motion, this group of amendments are the ones that I think are the biggest concern, and I share all of the concerns Pat outlined. And you know, one of the reasons why pre-legislative scrutiny was introduced was to allow us to kind of tease out a lot of the kind of questions which we're going to ask now, and not just get responses from yourselves, but, for example, get responses from, councillors or city and county managers from the areas that could be affected. And the difficulty is because this was designed to fix a particular problem. The way in which this is designed may work for some areas and may not work for other areas, or it may work for one part of a geographical area that will become one of these urban area committees. But we don't have the opportunity to tease that out with those organisations or those individuals. And I have to say, while the plebiscite stuff, I can kind of see your logic of introducing it, particularly with the deadline for the registration. I'm still at a loss as to why we're dealing with this very significant proposed change to our local government structures in this way. So the questions I have are as follows. The first is, if I read it right, you could have an urban area committee that's made up of a very large geographical portion of one county and a very, very small geographical portion of another county. But they'll have exactly the same representation in terms of the numbers. And there is a kind of a democracy question around that in terms of the proportionality of the representation that they have. And if I read it right, the voter-based difference can be very, very substantial. And if you could just clarify that with as much detail as possible so we know where the upper and lower limits of all of that would be. The second thing is, while obviously the only voting members of this are elected members, there's no guidance as to those elected members being in some way representative of the councils that they come from. So, for example, if one party has a simple majority in the council, they could dominate all three elected positions, rather than having something that's at least proportionate or whatever. So again, if you can just kind of clarify exactly how that would work, that would be important as well. The second thing is the staff in the new section 4016, and correct me if I'm wrong, and this is part of the difficulty of struggling with something we've only had 2 days to read. It seems to be that the staff requirements can be decided by the committee, irrespective of whether the city or county managers or chief executives approve. And I just don't understand how that works from a HR point of view, from a staff management point of view, from a resources point of view. Who's going to replace those staff for a period of time? It also doesn't seem to be any level of consultation with the elected members of the broader electoral authorities. And again, please do correct me if I'm reading it wrong, so that this committee this super committee of 8, if I have it right, the 2 chairs and the 6 ordinary members, they'll agree the plan. But it's a kind of an extension of Pat's question. Do they have to go back to their 2 respective local authorities to get that approved? Do they approve it themselves? And how is that process outlined? There's then the issue of costs, Minister, which is they're making very profound decisions. Now, they may be making really good decisions, by the way. They may be making decisions that are very popular, but the local authorities will have to bear the costs of those. And again, is that the most democratic way of doing it? And how is all of that determined? Likewise with zonings. You could have very controversial decisions around zonings, which could raise all sorts of complicated issues. I'm not clear around all of that. I'm very uncomfortable with Amendment 11.
Members, there is a vote now in the chamber.
I'm almost done with questions.
I'm going to let you finish and then suspend. Is that right?
I'm very, very concerned by Amendment 114, the new section 42, in terms of the hierarchy of the county development plans. And I'm just genuinely interested in the logic of that, what the thought processes were, etc. I'm also concerned that I'm not convinced there's been sufficient consultation with the elected representatives and the managers in the affected areas. So, in your answer, could you tell us the areas in which you think this will apply to in the first instance? What engagement there has been with them on this specific proposal? Not what consultation happened in terms of the boundary reviews previously, but specifically on this. And then I may come back with a supplementary question on that. But without, Minister, wanting to reopen the war, given the difficulty week you've had in the courts, I mean, for example, if you were able to give us a real-life example of how this works, whether controversially it's your own area or another area, talk us through how you see it, because I am. I'll give you an example later. I am thinking of, and the only reason I'm thinking of Waterford is because of that population imbalance. But if you can find another example that allows you to tease that out with me, I'm quite happy for you to do it. But genuinely, Minister, I've lots and lots of big concerns about this. And again, we're here, what time are we? 10 o'clock. And this is huge stuff. And I really don't think this committee has been given adequate time to tease through all of this. And it's not that we want to be awkward, but we want to do our job properly.
Just before we suspend, members, can I ask, are you willing to extend till 11 o'clock by the time we get back from this vote? We're sitting till 12, so in the chamber.
What time are you going to recommence? Some of us got caught short the other time. We didn't delay over much.
Well, whenever the vote's over, we make our way back.
No, but can you just give us the time? Because, as I said, a very important section of the bill seems to have gone through very fast.
I have the list, so when we come back, David is next to speak. So
No,
whenever
but
David
can you tell
arrives,
us, give us a time?
well, whenever David, when the vote is taken, we leave the chamber and he comes.
I literally
Eamon, I'm not being awkward with you. It's plain. When the vote is over, we walk back. As soon as there's members here and David is the next speaker, we'll start. It's as simple as that. So, members, I propose that we suspend to allow members to vote and reconvene once the vote is over. Thank you. Consideration of the bill in public session. So we're now in public session. David, the floor is yours.
And like previous speakers, I just want to first of all say I'm not a member of this committee, but I am concerned about Part 6 of this bill and the urban areas which are being proposed. I think, Minister, it would have been better if this was brought forward as a standalone bill. At least then there would be an opportunity to properly tease out what all of this means, the implications of what Part 6 will mean for local authorities. It would have provided this committee with an opportunity to consult with the stakeholders and also have a consultation process. So I'm a bit concerned that this is being brought forward as an amendment to a bill that deals with something else, and I think that will cause concern for councils across the state who will be affected by this. And I just have a number of questions that flow from the amendments, because there are a number of things that are not clear. It says that the Urban Area Committee shall appoint members from local authorities, 6 in total. So I would imagine if there's 2 local authorities, it would be 3 and 3. So what does it mean by appoint? Are they elected by the members of the local authorities? How are they appointed, and how does that work? And then what's the relationship back when they are appointed or elected? What's the relationship back to the local authority? It also says that the people who are appointed should have experience and expertise in provision of transport, provision of housing, development of infrastructure, business and trade. Who determines that? And who determines what expertise is and what experience is? Is that going to be more defined? I do have a concern, Minister, in relation to the local area plans and the making of local area plans and the amending of local area plans. Maybe I'm wrong and you might clarify this for me, but it seems to suggest that these urban committees, once established, can formulate their own separate local area plans that could supersede local area plans already agreed by, we'll say, local authorities. That would be very problematic and cause a lot of tension and a lot of difficulties for local councils and indeed for CEOs of those councils. So I think that needs to be properly explained. How is that going to work? It also says that a local area plan prepared by a planning authority insofar as it applies to the urban area in respect of which that urban area committee was appointed causes me concern. Another area of concern is in the area of development plans. Again, it seems to suggest that this urban committee could amend development plans which are crafted democratically by local councils, and how is that going to work out? And just my final question in relation to this would be just trying to struggle to come up with an example maybe of how this would work. So maybe if I was to pick, we'll say, Waterford, Kilkenny as an example, I think it would be a good example. I think you would agree that the population of Waterford City, the metropolitan area, would be 45,000. The population of the part of Kilkenny that would be known as Ferrybank, that if this was to be put in place for, say, the Waterford Kilkenny area, I would imagine that this urban area committee would then cover an area with a population of 50,000, the vast majority of which would be in Waterford. But if you had 3 reps from Waterford and 3 reps from Kilkenny, that wouldn't be seen as very democratic and would be highly problematic as well. And also then, what consultation has there been with the CEOs of any of these councils? What consultation has there been with the elected members? I contacted a number of elected members from Waterford from all parties, and none of them were even aware of these amendments or what this would mean. So what engagement was there with the representative bodies of local councillors? So for all of those reasons, Minister, notwithstanding whether or not there is some logic to what you're proposing, although I would have some concerns about it, it's a standalone bill, and it should be brought forward as a standalone bill. So my suggestion to you would be to withdraw these amendments, come back with a standalone bill, let's have the full consultation, let's have the second stage contributions. And if you feel there's logic to this, and if there is, then it can be teased out and people can put forward legitimate, proper amendments. But this process of just putting amendments in this way in a bill that's already past second stage is not the way to deal with what is a very complicated and, you would agree as well, contentious issue. And I think it would be treated with suspicion for that reason. So I would say to you, withdraw the amendments and come back with a standalone bill.
Thanks, David. Darragh?
Thanks, Gary. Just to say, quite a lot of what David has said there, I tend to agree with. These changes are very significant, and actually, in many respects, could be very positive. And I actually see what's being tried to be done here, particularly in areas that cross council boundaries. And that's one question that I did have. I got the list, and thank your officials for it, of the 8 urban area committees. I'm wondering, 1, how you selected them, and 2, is it restricted to just those 8? I could give you many others that cross council administrative boundaries. You know, in the 4 Dublin local authorities, I know Owen could and others could as well. If I take the Clongriffin area between Fingal and Dublin City, that's going to be a massive area where an urban committee, such as an urban area committee like this, I think would be a very positive thing. I think it would actually, because, you know, fringe committees like we have, Northern Fringe or Southern Fringe committees, don't tend to work. They tend to be run by officials. There's no elected members on them. There's not really any buy-in. So I actually think the concept, I think there's a lot to it. I have a couple of questions, and I'm conscious of the time here as well. And something as significant as this, I think, deserves more scrutiny than we're able to give it in this space of time. Firstly, the municipal district councils aren't mentioned really in this section as such. So the appointment of the people to the urban area committees, if you take the 3 members from each local authority, do they come from the municipal district councils that in those areas or anywhere in the councils? Because that's not specified in this. And maybe I'm missing it. I can't see it. If it is, that's fine, but I think it would have been that it's the municipal districts that cover the areas that cover. Again, then the ratio of members. So if it's a situation like Waterford and Kilkenny that I was talking to Deputy O'Brien about, or something where you have a small portion of another local authority in it, are you still allowing a 3-3 split between the elected members, or should it be proportionate? Because then I think you're going to have a much greater weight of numbers from one local authority into another, and then so that's another issue. The other issue then is the appointment of the 4 lay people, for want of a better phrase, these experts in these areas. I do agree with David. I think we need to be, who sets down, who decides that someone has experience and expertise in those 4 areas? And I've no fear with having people, non-elected people, involved. And I know that they don't have a vote. That was my initial concern initially when I thought, you know, are they going to, so they're not going to have a vote. That's fine. I think advice at a committee level in these areas, I think, is a good thing. They don't have a franchise, so that they should not have a vote. The local area plan piece and the development plan, if we go to section 32, and its definition 17A under that, all in relation to the local area plan, it looks to me that we're saying an urban area committee may at any time prepare a local area plan. Now, how does that work with the sequencing of development plans as it currently stands within local authorities, the submission of those development plans to your own department minister, but indeed the preparation of local area plans? And do those plans, I take it from reading this, actually supersede the development plan in those areas. And maybe they don't, but from my reading of this, it actually looks like they do. So if we set up the Urban Area Committee and it decides to bring in a local area plan, that by making those changes in the local area plan, the area, that it changes automatically the development plan in those two local authorities. Do the council members who have the reserve function right now for development plans have to ratify those changes? There's a load of questions, and I actually think I do want to say the thinking behind this I think is very good, but you know, it was only brought in yesterday. I would like more time to actually add to this, because I think we can work something that would be particularly good. I think there's a lot to it. I think it could work in other areas bar the 8 as well. So look, I'll leave it at that, but I have a lot of questions, and I think if we worked on this together as a committee, I don't see delaying this till after Christmas at all. I don't necessarily think you need a separate piece of legislation. I think maybe bringing it back at report stage with these. I have a lot of unanswered questions, and I don't want to be negative about this, because I think there's a lot of good in it, but I think maybe there's more work needed to bring it back at report and allow some input from the other parties and members of the committee to strengthen this. Because final point, and I promise the final point, David Cullinan has made, has there been consultation with the 8 urban areas that you've picked as well, certainly with the local authority members or indeed the chief executives there? I think that's important. I think we should ask them. This is significant. I think significant and potentially very positive. So I'm not raising any of these questions from a negative standpoint. So I'll leave it at that.
Fergus.
I don't have knowledge of the 8 urban areres. Yeah, no, I'd like to where they are.
We got them at the brief. Yeah.
I wasn't invited to any briefing. Not that I'm complaining.
Athlone, Bray, Carlow, Carrigan, Shannon.
Sorry, can you just say them again? Sorry.
Athlone, Bray, Carlow, Carrigan, Shannon, Drogheda, Limerick, Portadown.
Athlone, Bray. Sorry, yeah. So I just
Bray,
need to
Carlow, Carrigan, Shannon. Right quicker.
Right. Okay.
Drogheda.
Sure.
That place. Limerick.
Right.
Port Arlington and Waterford.
No, you can laugh if you like, lads, but this is very important for me, because what I'll be able to tell you, I'll be able to inform you of something that did actually, if I can just be serious for a minute, something that did actually happen in County Louth and County Meath, where the 2 county councils met and they decided that they needed an area plan which covered the jurisdiction of both. Hold on, we're not finished, we're only starting. When that happened, right, the plan was produced and published, and people in the councils bought into it. But the local municipal council, or the local district committee, didn't agree with it, because they didn't like the zoning that was in it. What happened was, the legal decision was that the consensus of the officials of Meath County Council and Louth County Council in this area plan was null and void, had no status, and the local area committee rezoned hundreds of acres, and it's a huge scandal in planning in East Meath. Now that's what the laugh is about, if you like, but that's the problem that the Minister is trying to address. Can I make this point?
No,
that is the truth. That is the absolute total truth. And the issue here,
I'm not putting any. It was a comment that the Minister made.
No, but I want to make the point because it's something I feel strongly about, and I usually don't talk too much at these meetings. And I'm sorry, I can't. I just want to get this point clear.
The floor is yours, Fergus.
Thank you very much. The areas that I mentioned earlier, which have some of the problems of the areas you've identified, were the towns that I identified as Drogheda. Swords isn't in that list. Dundalk isn't in that list. Bray is it? I think, yeah, Bray is in it. Navan isn't in that list. And Kilkenny isn't in that list. Now, they're the biggest towns. And the point I think I raised earlier holds water, in that it's because of the increase in the urban areas, particularly around Dublin. So I don't disagree with the idea, but the problem is, how do you initiate it, right? Who initiates it? Must be both councils must agree. It doesn't include in the people who are outside of the elected members. You have transport, knowledge, housing, infrastructure, business. Planning isn't in that, and I think it should be. Because And the other question is, if you have a group around the table, will they all have equal status in terms of votes on what the original or what the plan is going to be? And then obviously you'll have the problems between elected and non-elected members. But I'm not against it in principle, but I know where the consensus of county councils didn't work. But the difficulty I see, if you don't get the buy-in, you see, of say even if you have a co-joint area, that the municipal districts in the councils, would they make the recommendation or would it be the whole council? I think that would be important as well. And you could get a difference of opinion. The municipal district mightn't want the thing to happen, and I would say that's probably, if that was a Meath-Louth situation, you could have difficulty there. And I would agree with the members who said that they welcome the discussion in principle, but I do genuinely think we need to think it through more, and whenever the next stage of the bill is passed, it can be fleshed out. But there are dangers in it, right? There are serious dangers in it, because what you suggest is that some areas can have as many as 99,999 people living in them. So I think the point is well made about moving outside, a small little map. It could be a huge area. So I think that in parallel with this, Minister, I think you need perhaps a paper, certainly on why you selected those towns, the reasons why, and I'm not disagreeing with that selection because I think it articulates my own point of view. But I think you need to plan it because in some cases you might be setting up an area committee when you actually need to have a complete reform of the whole council functional area. So I think on that basis, I accept it is very late in the day to be discussing it. I think there are important issues here, and I welcome it in principle, and I'd like to tease them out more if I can. Thank you,
Thanks,
Chair.
Fergus. Eamon.
As I said earlier, these are extraordinarily big changes coming in late in the day of the bill, with no consultation with the wider public. I certainly only for two issues in the bill that I noticed. One was the Galway issue and another issue that came up again yesterday. Would have probably not engaged with this detail. Now, I don't think anybody can argue with the idea, if you take a Carlow or a Athlone or whatever, of trying to have some coherent planning between the two parts of the town. And that has been something I think that has been grappled with. So the basic idea of committee is fine. But I think we all know that the devil's always in the detail. Big, broad policy is awfully easy. Its implementation in detail is always the difficult part. And there are a number of serious trends here that I'd worry are a precursor for a much wider application of a new process. I've heard what people have said, if you have a little bit of one county in with a massive part of another county, for example, if you have a little bit of Kilkenny and Waterford and all that, and how are you going to divide up the elected members? So I'm not going to repeat what was said. Now, I don't like corporatism as a form of government. I like democracy. I really, really like democracy. I like the egalitarianism of democracy, where the so-called least in our society, in terms of the elites, have the same shout as the people who have the PhDs and all the other things after their name. And I have to say that the life I've led has been very interesting, in that I often found, having moved from a relatively middle-class Dublin upbringing, where most of my family and most of my people I went to school with had access to third level at a time. Not everyone had access, and moving down to the west of Ireland, I found one thing, and that was that the ordinary people who had been to that greatest of all universities, the University of Life, would buy and sell you, thought-wise, foresight, any day of the week.
To interrupt you, Eamon, I'm going to let you finish, but just to let members know there is a vote happening, and I would suggest to members, whenever Eamon's finished, that we will adjourn and we'll reconvene at 12:15 to finish the bill tomorrow. Because there's going to be a number of votes called, so members are free to go whenever they want, but Eamon, the floor is yours. Yes, yeah.
So,
Sorry, just 1 second. 12:15 will be the votes tomorrow after the voting block. So it'll have to be after the voting block.
Yeah, and I'm moving a housing bill at first stage after, which the committee will know about, after leaders, so that's at about 12:45.
We would hope to convene once we're finished with our joint committee in the morning. And if that works, it works. If it doesn't, the select members will try and figure that out tomorrow in the private session.
Okay, so what time are we in the morning at first? 9:30, that one.
9:30.
Okay, cool.
Yeah. Yeah. Sorry, Eamon.
it's worth starting because I've the reason I want to say.
It's up to yourself.
Not feeling false. Sorry.
No, they were laughing at me.
No comment.
Okay, would you rather have the run of it tomorrow? We start with yourself tomorrow, then would that be better? So members, if we adjourn CNADA and we reconvene tomorrow after the Joint Oireachtas Committee.
As an exceptional measure, since I'm not on, I won't be at the meeting tomorrow, but want to attend, can somebody let me know when they've decided what time to reconvene? Okay, thanks.
Chair, could we just officially thank the staff for staying so late? It's
Yes,
Sunday
absolutely.
and we really appreciate that. And obviously the officials.
So thank the members, the officials and the Secretariat, and we'll reconvene tomorrow.